Sir, Group Talk 35. Serial number 35.
Yes. છે વિટનેસ છે એમાં
પંચને બોલાવે તો એક મોબાઈલ કબજે સાદો પંચને
ઓકે લઈ લે બોર્ડ એડજસ્ટ કરી દો
લાંબુ
ચાલે
એડવોકેટ મનીષાબેન સાહેબ આયા છે બધા છે
Practically,
how long is going
serial
to
number
take?
27.
How long it is going to take?
Likely to take one session then.
તો પછી વિટનેસ ને બપોર પછી રાખો ને
સર બપોરે પેલું મારું ખંભાત મેં આપને હું અત્યારને લીધે મેં ત્યાં બપોરે ડોક્ટરને બોલાવ્યા
વેરી ગુડ તારીખ આપો
એવું હશે તો સાહેબ રિપોર્ટ આપો
તારીખ આપી દો એમને એટલે હા એવું કરે હા કોલ આઉટ કરી નાખો
રાકેશ
હા એવું કરો એમને બપોર પછી હોય તો બપોર પછી હોય ને પૂછી એમને કહી દો બપોર પછી
કઈ વાંધો
એટલે ફિટનેસ ને કહી દો તો એમને બીજું કામ બતાવીને આવી જાય બપોર
ઠીક.
પછી
3 વાગે બોલાવજો તો.
પડે
3 વાગે બોલાવજો.
હા બાકીનું બીજે એડજસ્ટ થતું હોય એ કરી દો હા sometime before we start.
Sure.
સર 11મી ગુરુવાર આવશે
તારીખ ક્યાંથી લઈ લેવાનું એડજસ્ટ કરી દેશે પહેલા
ગુરુવાર સિવાય એમાં ચૂપ લઈ જાઓ
આપી દીધું જાહેર કરી દીધું. Thank you. Yes. Sure. બહુ ડિસ્ટર્બ ના કરતા પેપર બ્લેન્ક કરજો. રેકોર્ડ આવ્યો છે મંગાવી લેજો ચાલશે.
May it please, my lords.
Yes, please.
The present appeal is preferred against the order passed by the commercial court, whereunder the issue of limitation has been held against the present appellant. If I may take my lords to the operative portion of the order. Just for a moment. The trial court holds that on the issue of limitation, we hold that the suit is filed within the period of limitation, and therefore the preliminary issue on perusal of the provisions of the law, the documents produced, oral depositions, cross-examinations, etc. It is held that it is a continuous cause of action, and therefore hence the date, if I may take my lords, relevant
Yes.
paragraph 31, operative portion.
Ji.
And then I'll take my lords to the fallacy of that order, but primarily paragraph 31,
Yes.
on perusal of the provisions which provided in Article 14 of the Limitation Act is that for the price of the goods sold, delivered, when no fixed period of credit is agreed upon, the period of limitation of 3 years, which begins to run from the date of the delivery of goods in this regard, considering the above all facts and circumstances, the chargeable amount dues during the continuation of the dealings between the parties pending from 81 till June 2005, the amount of 10 crores. The last installments were deposited on 7/1/2005. The amount which deposit was part payment of the dues, which demanded by Gale for a period from 81 to 92. And as per the contents of Exhibit 97, Article 2, defendant has duly accepted the arrears receivable by the seller for period from 92 to 94, and any arrears earlier for the period of 16/5/92. Hence, the disputed amount between 82 to 87 is contained in the period of any arrears earlier for the period of 92, when payment of any item in series of sale and deliveries of goods were paid, and such payment towards the particular goods or sale and deliveries of the good, the period of limitation in respect of extending from that. Hence, the date of the delivery of the goods was extended, continuously continued, whenever plaintiff ONGC has supplied gas to the defendant GSFC. That last supply stopped in 87. The suit is filed in 2008 to 5/2008. Therefore, any arrears pending from 81 to 92, it can be receivable by the plaintiff, seller, and the ministry advised to put the defense before the commercial court on 22/6/2005. Therefore, 3 years completed on 21/6/2008, and the present suit is instituted on 2/5/2008. It is crystal clear that the plaintiff has filed the present suit within the period of limitation. To demonstrate before my lord the perversity of the order, I wish to take my lords to the chronology of events very briefly. I've culled out the chronology with necessary exhibit numbers and the pages.
Was this submitted before any of the courts? Because I just want to be sure that, there is no dispute per se.
There is no dispute per se on the
So,
facts.
okay.
I will take my lords to the reply
Very good.
given by the original
you-
plaintiffs and the
It was
present.
only limited to that part. But
It's
anyway,
only, no, but I'll take to the reply and my submissions will based on the reply.
very well,
The factual narrations as emit from the reply. I will make good from that.
well,
So factually, I don't think there is any dispute. My submissions and interpretation on the document may be different, but on factual aspect, there would be no difference.
Ji.
In 69, and in the year 1969, being 3/1/69, an agreement was executed between ONGC and GSFC. It was for a period of 15 years. The period came to end. The period came to an end on 25/12/81.
Ji.
This is an undisputed position. There was admittedly an arbitration clause. I'll take my lords to that in a bit.
Ji.
A communication, one of the clauses, clause 2, if I may take my lords to the clause. मैंने paper book आपको चुनने को है। Milord, may I be permitted to tender a paper book?
Please.
The other side also.
that be
आप पीछे?
happy છે તૈયાર પેપર બુક
हाँ, हाँ, तैयार છે. आप पीछे.
અલ્પેન્દ્ર ભાઈ પેપર બુક પર વોલ્યુમ 1 અને પેજ નંબર્સ લખેલા છે સાહેબ એ પ્રમાણે એટલે બધી જ કાઢવી પડશે પેપર બુક 2 માં છે આ ડોક્યુમેન્ટ
હું જોઈ લઈશ પેપર બુક વોલ્યુમ 2
Yes, paper book volume 2, page 383. Same as High Court. I have.
But then it is the same.
It's the same and I've informed him also, it is going to be the same. Same page. The agreement starts at page 384.
yes
This agreement is made on the third day of the month of January,
yes
which expression shall so and so required so and so, include so and so between so and so, and it shall, and it's for a period of agreement, page 385. It's for 15 years, which stands admittedly concluded on 25/12/81. My note states that.
Ji.
And it's not in dispute. Clause B, if any of the parties should desire an extension of this agreement on the same terms or on the revised term, the said party shall give a written notice to the other party at least 2 years prior to the date of termination of the agreement. Since 81 is the closure, 79 would be the date.
Ji.
Shall be executed at least 1 year before the date of termination, unless and until it is done, the seller as well as the buyer shall be free to make alternative arrangements for selling and buying gas after the expiry of 15 years. So after 15 years, if you wish to continue on the same term, either of them may approach 2 years prior thereto, failing which either of them it will be open for either of them. Accordingly, a notice was issued on 1/12/79, item 2 as stated, which is at exhibit 77, page 275, paper book 1.
Ji.
We refer to the above agreement under clause 1A of the said agreement was to remain in force for a period of 15 years from 26/12/66. Under clause B, either party has the option to renew the said agreement, and for such renewal, such party has to give a notice of 2 years prior to the date of termination of the agreement. Therefore, the agreement will stand terminated on so and so. In exercise of the option reserved to us, we hereby inform you that we desire to extend the agreement for a further period of 15 years on the same terms and conditions as are contained in the said agreement. It is not out of place to so and so, so and so. So therefore, a request was made that it may be extended. A reminder thereof was also sent, which I need not take, but it's on identical terms. Exhibit 78, page 276. A second reminder, which is at exhibit 79, page 277, and the fourth reminder at exhibit 80, page 278. Not necessarily all repetitions of the same content. Thereafter, ONGC addressed a letter. This date is relevant. A draft agreement is received. It's just 2 days before the conclusion. So the agreement ends on 25/12. Just 2 days prior thereto, a draft agreement is received, which is at page 279, where the price sought is 1,538. The earlier price, if it be noted, was 320. Nothing would turn on it because they're not arguing on merits. I'm just going on the dating. So it was 320. Here it becomes 1,538. Necessarily, it was felt that there is a genuine dispute because the draft, which is received just 2 days, 2 days prior to its termination, has an escalation which is 5 times, and therefore an arbitration notice was issued at page 87, paper book 1. Can you just help me on pages? So come and go. Page 87. Yeah. On behalf of a client, so-and-so, you are hereby aware that agreement dated so-and-so was entered into. It was later provided either party shall have an option to renew the agreement for a further period of 15 years. And thereafter it is stated, in light of the aforesaid dispute and differences, page 188, page 125.
This is me. Printed picture.
Oh, so page 88.
G.
Page 88, second paragraph. In light of the aforesaid dispute and differences arising out of the agreement, we have instructions from our client to give you notice that our clients hereby appoint Mr. J.M. Shellett as the arbitrator under clause 14 of the said agreement dated 3rd January 69, and have to call upon you to nominate your arbitrator within 15 clear days of the receipt of this notice, failing which Mr. Shellett will be declared as the sole arbitrator pursuant to the provisions of the Indian Arbitration Act of 1940.
G.
So 15 days time, we are appointing so-and-so. You may select whoever you deem appropriate to be appointed as an arbitrator. Second notice is issued by GSFC on 28/4/80, which is Exhibit 80. We may not go to it. Page 278. It's identical tenure. ONGC issued a letter.
Yes.
I'm sorry, I stand corrected. A reminder notice was issued on 24/3/82, which is page 89, Exhibit 44, against which ONGC preferred civil miscellaneous application number 85 of 82 under section 33 of the old Arbitration Act of 1940, challenging the appointment.
Okay.
More relevant is the order which is filed, because along with this miscellaneous application, under Order 39 Rule 1, an application was also preferred. An ad interim ex parte injunction was granted to ONGC by the civil judge upon a purchase being filed by ONGC that they shall not stop the supply of gas to GSFC without prior permission of the court. And therefore, regards to the same, ONGC continue to supply is their case. The purchase is not on record, but if the reply filed by ONGC is examined, this factum is noted that upon a purchase being filed, I'll take my lords to that. Paragraph 2.7 of their reply. They have filed a reply, paragraph 2.7. I may just be permitted to read. The Honorable Court, before passing, huh?
Where is it in the paper book?
Main appeal, my local reply filed.
Oh.
Correct. They filed a reply. It must be with my lords.
Everything on record in the correct way. CD
G.
2.7. So they've given the chronology, since the purchase is not on record,
Okay.
to substantiate what I am stating, that upon a purchase being filed, that they'll continue to supply gas and will not stop without approaching the Honorable Court or approval of the Honorable Court, and ad interim stay came to be granted.
Yeah.
Paragraph 12.7, the Honorable Court, before passing the order on the injunction application, had asked for a declaration from the opponent corporation that it will not stop the supply of gas to the appellant, even though the contract had expired in 18-1. The said declaration was obtained in order to safeguard the interest of the appellant.
Ji.
After the said declaration in the form of pushes given by the corporation, Honorable Court granted injunction as prayed for in para 11. And therefore, I'll take my lords to that injunction order, which is on record at page 108 of the first paper book. Where is the order? Just a moment. Twenty-six. You say 96, you say 108.
108 upon.
It's 108 upon F.
F and G perhaps, there are two orders.
108 upon
Yes,
F.
I've got it.
Yes. So heard so-and-so, read the application, affidavit and documents carefully, considering the material before me in light of the submissions made by so-and-so, the reliance placed on him on certain authorities. And in view of the pushes passed today, I pass the following order at this stage. Ad interim injunction to issue against the opponent on terms of the prayer made in para 11. This application is valid up to 27/4/82. Urgent show cause notice. Issue process today. So, my lord,
Ji.
an interim injunction is granted against proceeding with arbitration proceedings, appointing of Mr. Shelat as the sole arbitrator upon a push is being filed, which say that they will continue to supply.
Ji.
Subsequently, ONGC revised the price in 82 to 2,000. Page 95. Page 95.
300, revised price of.
Yeah, that's okay.
11A seems to be the prayer, was it? 11A.
11A is the prayer. Should I take my lords to
Opponent
that?
company may be restrained by an ad interim injunction of this honorable court
To proceed with the arbitration
from
procedure.
entering into or further reference to under arbitration.
Yes, under arbitration, because we noted that there is a genuine dispute
Hmm.
with regard to the pricing for the,
Okay,
so we appointed Mr. Shelat. We said 15 days, just Honorable Justice Shelat. And we said that within 15 days, you may appoint your arbitrator. And in case you do not, then the former retired judge, Honorable Justice Shelat, would be the sole arbitrator, against which they preferred an application. That application, a pushes was given, pursuant to which the Honorable Court passed an order and said that you may not proceed with the arbitration by appointing a sole arbitrator.
Ji.
Thereafter, the government of India fixed the price of gas at Exhibit 95, page 334. Same paper. Now, this pricing is to remain relevant for all and for times to come. And based on this, all payments are being made today. So this is not in dispute. All disputes precede this date.
That's the correct. Payments are being made pursuant to ultimate price fixed by Honorable the Apex Court. This document was subject matter of litigation, which went right to Honorable the Apex Court. Ultimately, it is the Honorable Apex Court which determines the price and the basis thereof. And it was being paid now to GAIL. Erstwhile, we have not received anything that's wrong with this.
We are,
The prices are fixed by Honorable the Apex Court.
no,
That's
no,
the
that
document
is,
correction.
no, the price, I'll take my lords to that judgment. That pricing is not post the Government of India pricing. Government of India pricing, I will take my lords to that. In any case, the quantum is not in dispute right now. It's a limitation.
Not the price now, after honorable ethics.
Page 334.
Yes.
On 3187, the Government of India fixed the price of gas at 1400 plus other levies. I am directed to state that subject to the concessions given in para 2, the prices of natural gas has been fixed as follows. Rupees 1400 for gas and landfall prices and for offshore, etc. For our purpose, it is 1400. Plus all the others, royalty, etc. The above prices could be exclusive of royalties, taxes, duties, and other statutory levies. The above prices will take immediate effect from the date of issue of these orders and will remain in force till 1999, etc. For the period of supply prior to the issue, page over, page 335. For the period of supply prior to the issue of these orders, the following instruction shall apply. In cases where there is a dispute on prior or provisional prices has been agreed to subject to government decision on prices, may negotiate with the private consumers the price of gas to be paid for the period prior to the issue of these orders with reference to the contractual conditions, For consumers in the public sector, ONGC should send a comprehensive note. This is relevant. ONGC is called upon to send a comprehensive note on the present status, giving details of the price demanded by ONGC, price being suggested or paid by the concerned public sector undertaking, the contractual provisions with the arrears till date, so that this could be taken up with the concerned administrative department. So the Government of India determines the price at 1400 plus, and this is operational till date. And it is stated that if for the prior period, ONGC should send a detailed note, whatever its dues outstanding with any public sector undertaking or any of it will be a detailed note be sent, and it shall be as per the contractual conditions. So the reference is to the contractual condition. In the facts of our case, the contract stands concluded, admittedly in 81. The detailed note which is sent, which is at Exhibit 191, dated 5/5/87, paper book 2. I'm taking my lords to this because all this is referred to as an extension of the period of limitation. A note called for by the government is said to be an extension of limitation. A note submitted is also said to be an extension of limitation. This note is submitted in 87. Gas pricing, kindly refer to your letter dated so and so. It is bearing the same date, 87, 30th January 87. And then, of course, the details are given.
Date appears to be 11 to 85.
I'm sorry?
Date appears to be 11 to 85. This note of ONGC.
Is no.
557 page. Are you reading?
I'm reading page
559, sir.
559.
Okay.
It is 5/5/87. This note at 5/5/87.
Yes.
659.
659. Sorry. 659. Sorry. My mistake.
659.
659.
Okay.
This note, it is contended, extends limitation. This is a note forwarded by the plaintiff corporation, giving details with regard to the amounts due and the pricing. So far as GSFC is concerned,
Sorry to interrupt, but you said that this is the extension of limitation.
that is the
How-
contention.
How is that construed to be an extension?
That is a contention.
Ah.
The cause of action, if I take my lords on the plaint,
Ah.
the cause of action says all this is extending limitation. Straight away, plaintiff will be seen, paragraph 13,
Paper book one para.
paper book
Page-
1,
Page 13.
page 13. Let me show how they explain period of limitation. Cause of action, page 13.
30, you said.
1-3,
One.
1-3. So that my lords have the context.
Yes. Yes.
The cause of action for the suit arose when the agreement between the plaintiff and the defendant has been executed and the same expired. I taken my lords to that date, 25/12/81. And it also arose when the defendant wrote a letter requesting for the execution of the agreement, which is on 1/12/79. And it also arose when the defendant served the plaintiff with a notice intimating the appointment of an arbitrator, which would be 2/3/82, and calling upon the plaintiff to appoint the arbitrator. And it also arose when the defendant, by letter of 24/3/82, its advocate informed that the arbitrator will act as a sole arbitrator. And it also arose when the plaintiff tried to resolve the issue amicably. It also arose when the plaintiff filed application on 85/5, on application number 85 of 82 in the court of the civil judge at Vadodara, challenging the appointment of the arbitrator. And it also arose when the purchase was filed by the plaintiff in the said matter against the stoppage of the gas supply to the defendant. It also arose when the Honorable Court in civil miscellaneous application passed an order to stay, order of stay in the said petition. That stay was for arbitration proceeding. Nothing precluded them from filing a suit.
Ji.
That is not a petition, is not even meant for that.
Ji.
It also arose when the government of India fixed the price with effect from 31/87. It also arose when the Honorable Supreme Court, by judgment dated 4/5/90, upheld the price fixed by the plaintiff, and by the judgment dated 26/7/2001, upheld the right of the plaintiff to claim interest. It also arose when the issue of recovery of dues from the plaintiff, the fertilizer company, was submitted to the central government. Now, it also arose when the issue of recovery of dues of the plaintiff from the fertilizer was submitted to the central government. This submission is what I was taking my lords to.
Okay.
There are two notes which they have filed, pointing to the central government that these are what are dues and receivable.
Okay.
It also arose when the government of India decided to hand over gas marketing function to GAIL. It also arose when the agreements were executed between GAIL and the defendant. It also arose when GAIL issued a letter to the defendant for payment of plaintiff's dues. It also arose when the defendant filed special civil application before the High Court of Gujarat. And it also arose when the defendant deposited 10 crores towards the dues of the plaintiff. I'll point out it was a without prejudice deposit, but be that as it may. It also arose when MOPNG, its letter dated 22/6/2005, informed the companies to take action as per the terms of the contract. And thus the government of India left the issue undecided, and it also arose when the plaintiff served a notice. Serving of notice does not extend limitation. On 23/1/2006, calling upon the defendant to pay the outstanding amount. It also arose when the defendant denied to pay the dues, as the agreement between the parties executed at Vadodara and defendant is having factory so and so. So therefore, I'm taking my laws to the chronology, that every incident, every chronology is said to be reasons for extension of the period of limitation. Now,
Yes.
I'll just complete the chronology. Thereafter, my lord, this was the note which was first submitted. There is another note which was submitted. The date of this note also is relevant. 11 expected. Exhibit. Exhibit 111.
191. 193. 192.
So good.
193.
Page
665.
665
Paper book 2.
and 663. Both of 1990. 665 is a communication. Exhibit 193. Page khadi. 665. 665.
जी. April 24.
April 24, 1990. This is a communication to the Secretary, Ministry of Petroleum. During the meeting held on 19/3/90 in your chambers convened to discuss gas arrears due from GSFC and IFCO, you had required a comprehensive note to be submitted, bringing out sector-wise. This has been done in the enclosed note. Our claims summarily as under. For GSFC and IFCO, it comes to 300. etc.
Bringing of dues sector wise.
Yeah, bringing of dues sector-wise.
जी.
Bringing out the dues, correct?
जी.
Yes, dues sector-wise.
Yes.
So therefore, this is a communication address. This is also addressed in 1990. Pursuant to this, Government of India ultimately takes a decision and informs them. This becomes the moot cause of action. In the interregnum, I'll take my lords to various events which did take place, but just to complete the chronology. So it is Government of India first issues a gas pricing order. It determines the price which is to be paid, calls upon ONGC that you give details of outstanding, various sector-wise details of agencies, etc., which they give. I've taken my lords to both the communications. That ends in 1990. Then ultimately, after 15 years, in 22/6/2005, comes the communication which they say is the trigger for us to file the suit.
Government has asked them to do so. Is
Government of India has told them these are contractual obligations. You act in accordance with the contract.
Commercial. Not.
जी.
Page 369. Recovery of dues, page 369, volume 2.
Yes.
Recovery of
22nd June 2005.
22nd June 2000. This, they say, is a permission granted to a body corporate listed at the stock exchange. It says this permission is given to us and therefore we have filed it. Recovery of dues of ONGC from GSFC and IFCO. Special civil application number so-and-so filed in the High Court by IFCO and SCA number so-and-so filed by GSFC. I am directed to state that in pursuance of various orders passed by the Honorable High Court in the above matter, the issue of recovery of outstanding dues of ONGC against GSFC and IFCO have been examined in consultation with the Department of Fertilizers and Ministry of Finance. Now a view has been emerged that it will not be appropriate for the government to get involved in the matter due to following reasons. One, the matter essentially relates to a commercial dispute between commercial organization which has to be resolved within the parameters of the contract. So it's contractual obligation governed by the terms of the contract. If the dispute is resolved through a negotiated settlement, the cost thereof should be borne by the companies concerned and not the Government of India. The dispute relates to pricing of natural gas for the period prior to coming into effect of the administered pricing mechanism from 87. Government should not get involved in fixing any differential pricing between different section of consumers for this period. Further, as the administered pricing for natural gas came into effect in 1987, it would be appropriate for the government to give any approval. It would be inappropriate for the government to give any approval for pricing prior to this period.
Correct.
In view of the above, since the matter is a commercial nature, therefore the dispute may be decided by the companies involved, taking into account contractual provisions, the orders of the Supreme Court with regard to the recovery of dues by ONGC from private consumers. GB, GNFC, ONGC is advised to defend its interests appropriately. Since GOEL is also respondent in SES, GAIL may take appropriate action to defend it. So, one, there is a standard gas pricing order. Notes are called for, two notes which I refer to. One is of 87, the other is of 90. Those notes and culminate after 15 years in an advisory from the Government of India. Completing the chronology, in 1990, the Honorable Supreme Court confirms the price fixation by ONGC. If I may take my lords to that judge. Is it I have an extra. I have an extra copy somewhere. Extra copy. I have an extra.
You can use mine. Marking.
Check it. One, I'll just send it. I have a copy.
Yes.
The Honorable Supreme Court is concerned with the judgment and order which is passed by the High Court of Gujarat upon a petition which is preferred by the Association of Natural Gas Consuming Industries of Gujarat and others. Paragraph 2.
Yes.
ONGC was initially a department of the Government of India, but in view of its expanding activities in search for strategic and vital materials like oil, petroleum, and its products, it was set up as a body corporate. I emphasize it's a body corporate. It is not dependent on any advisories to take any action. It is not precluded. Neither is any injuncted. Yes.
Let this be recorded in
Yes.
exact words as she is saying.
Correct.
Because a lot could change of counsel doesn't really alter change of stance on party's part. So let this exactly what she is saying be recorded.
Please. ONGC was essentially a department. The turn will come, Mr. This. Mr. Vyas, don't need to get excited on the matter. Oh, I'm reading what the Honorable Court says. It says,
I'm excited, not for the.
correct. Its product. It's now a statutory corporation constituted by and under the ONGC Gas Commission Act. The Act provides for establishment of a commission for the development of petroleum products produced by it and for matters connected therewith, etc. Thereafter, my lords, we please to turn to the functions of the commission, not very relevant. Page over, section 15 empowers the commission to exercise. It remains a commission till the year 1993.
No, but how does this has been, the price has been fixed by the Honorable Supreme Court?
The Honorable Supreme
It's a
Court.
fact. Now,
It's a
we
fact.
are not to go, we just go, that's just a fact.
It's the
We
fact.
have
No,
gone
we-
through all of this.
No, I will not take my lords.
Okay.
So, my lord, I'm only reading section 15 empowers the commission to exercise all such powers as may be necessary and expedient for the purpose of carrying out its functions under the Act, Such powers include disposal of property, right and privilege, etc., etc. So it's permitted to enter into contracts. So it's a body corporate. That's all I propose to point out. However, the Honorable Supreme Court says, paragraph 39 at page 336, 436. At paragraph 39, we should again like to emphasize that different considerations may perhaps have to prevail if the treatment of ONGC. So it holds that ONGC is not a public utility. So if the argument was that it should be taken as a company involved in public utility services, the Honorable Court says, no, sorry, it cannot be done so. We should once again like to emphasize that different consideration may perhaps have to prevail if treatment of ONGC as a public utility is taken to its logical conclusion. But that is not the basis on which the present petition can be decided. Even at present, ONGC is supplying to public sector undertakings at a much lower price. That has not been challenged by those organizations, and the differential has also been upheld in principle by the High Court, rightly in our opinion. Fortunately, with the discovery of more oil wells in various parts of the country, the economy of the country is booming. Gas supply may also become more plentiful, available in time. The time will soon come when, for the evolution of proper schemes of distribution and price control. We are now concerned, however, with a price fixation regarding the supply to few parties who considered it all right to enter into contractual agreements for supply of gas to them on the basis of price fixed by ONGC. So far as the scheme of supply is concerned, respondents also stand by the existing contract scheme as they want the supply to continue. It is certainly not their prayer that the existing supply of gas, such as it is, should be considered a public utility and rationed to meet the needs of all industries and consumers in Bombay or Vadodara elsewhere. Nor is there any complaint today from any industry supply, etc. There is therefore no justification to strike down the scheme of supply on the basis of contracts. So it's a contractual matter. However, that thermal basis, the argument before the High Court was that it should be a cost plus basis. The Honorable Court says so far as the thermal equivalence basis is upheld, and therefore this basis,
Yes.
and the last 3 lines of this page, we would also like to add that now that the prices have been fixed by the government, since 87, gas has already been supplied to the respondent till then on the basis of the interim prices.
He lost
and
it somewhere around. The only objection that survives, therefore, is that the price for supply should be reasonable and fair.
Correct,
That was on page 436.
436.
Thereafter, where have you, then I lost your.
All right. So the Honorable Court says they have already given a pricing. If I take my lords to it, they gave the pricing. If my lords be pleased to see, the pricing is also referred to. The pricing is referred to at page 406. So this is the price at which they were giving to private sector undertakings from 76 to, in the year 76, it was 322. It continued till 78 at 382. Till 78, it was 504. And then in January 82, at page 408, the
Yes.
price escalated to 2095. The justification was that we have changed the manner of pricing. It is not cost plus pricing, it is thermal equivalence or alternate fuel available pricing. So whatever is the price at which alternate fuel is available, that is our basis. That basis is upheld.
Ji.
The Honorable Court upholds this basis and holds that in 87, Government of India has fixed the price. We should also like to add that now that the prices have been fixed by the government since January 30th, 87, and gas has already been supplied to the respondent till then on the basis of the interim prices, the implementation of the direction contained in this paragraph would be prolonged and unmeaningful exercise, and it would have been much better to fix some ad hoc price for this period. However, after hearing both the parties, in fact, so and so, but Interim arrangements were tried, did not work out, so the Honorable Court holds that the pricing as fixed by ONGC is in order. It's upheld.
Okay.
This judgment is of 1990. Our
Yes.
suit is filed in 2008, 18 years thereafter. Pursuant to this, thereafter, GAIL and ONGC signed a marketing agreement. That agreement is Exhibit 96, page 336. Paper book 2, first page. Not very relevant for our purpose, except that marketing is now entrusted to GAIL. And this agreement is entered into on 27/12/1990 between ONGC and GAIL. Thereafter, in the year 94, that is 30/12/94, GAIL and GSFC entered into an agreement for 6 years. At Exhibit 97, page 346.
Yes.
An agreement is entered into between GAIL and GSFC. Relevant page 346.
Ji.
Page 349 are the relevant term. Article 2, period of the contract.
'94 to 2000.
94 to 2000, it's for a period of 6 years. This contract shall come into force from 30/12/94 and shall continue to remain in force for a period up to 2000, subject to the condition that the arrears recoverable by the seller from the buyer on account of supply of gas by the seller to the buyer from a period from 92 to 94 and any arrears receivable by ONGC from the buyer on account of gas supplied earlier. So from 92, GAIL takes over, but prior thereto ONGC had supplied earlier by ONGC to the buyer for a period prior to 92 shall continue to be receivable by the seller, ONGC as the case may be, and the buyer undertakes not to fail to discharge the said obligation of clearing such arrears directly with ONGC sellers. The buyer further agrees and undertakes that in case of failure and or default on its part to discharge such obligation, the right or claim to receive supply of gas, either under this contract or under any matter whatsoever, shall not survive and shall automatically stand terminated. So this clause is a 6-year clause. It also includes a period from 92 to 94 and the period prior where ONGC was entitled to, ONGC continues to remain entitled to. However, it stipulates that in case you do not clear the bills, it shall be open for them to discontinue providing you for the gas. This contract comes to an end in 2000. This agreement stands concluded in 2000.
Ji.
The suit is filed in 2008. The period of limitation for recovery of the differential price is 3 years under Article 14. Interestingly,
Yes.
whilst the suit is filed in 2008, ONGC does move an application before the concerned court, CMA 85. If my lords recollect that our application was moved CMA 85 of 82
जी
for recovery of differential price and application is moved. That was where the prayer was made that arbitration proceedings be not proceeded further, where the Honorable Court had said,
जी
sign a purchase, give it to us, and undertake that you will continue to supply, based on which an interim injunction from arbitration proceedings was granted. At page 109 is this application.
जी
So it is not as if it is it's not as if ONGC was not aware of its entitlement. It is not as if ONGC was not aware that it needs to initiate legal proceedings. It files an application in civil miscellaneous application filed under 33 of the old Arbitration Act of 1940. Page 109, paper book 1, volume 1. Therefore, at page 109, this is an application which is filed for recovery.
yes
This is also filed in 2003. Therefore, the whole argument that it is only when Government of India gave us the advisory that you proceed further as per the terms of your contract and protect your interests that we have filed a suit within 3 years is belied by this very application which they filed. In civil miscellaneous application 85 of 82.
जी
The afore referred proceedings have been filed by the applicant corporation
which page is it
at page 109. I'm sorry.
जी
Paper book.
yes yes
The afore referred proceedings have been filed by the applicant corporation on the 18th of April 82 under provisions of section 33 of the Arbitration Act, read with 151 of the Civil Procedure Code. And for that order that the Honorable Court be pleased to declare notices issued, notices of the opponent advocate dated so and so, appointing Honorable Mr. Justice J.M. Shelat as the arbitrator as illegal and invalid, and further that the opponent had no right to ask for arbitration in the matter, entering into further agreement for supply of gas. The applicant has also prayed for permanent injunction, pending the application, having also filed an application below Exhibit 5 under provision order 39 so and thereafter, my lord, paragraph 3, the Honorable Court's order is quoted, which we had read earlier. Thus, the Honorable Court had constrained the applicant to pass a proposal that it would not stop supply of gas to the opponent without order of the court as a precondition to the grant of injunction as prayed for, which is why the Purchase Exhibit 7 was passed. And as per the same, the applicant has continued to supply gas to the opponent on the price of gas as agreed with the agreement dated 69. As such, the applicant was not required to supply gas. However, in light of the purchase and the consequent order, supply of gas was continued. So they say it's pursuant to the order of the court, we've continued. Pending proceedings and application below 19 was filed inter alia stating that since the matter is pertaining to enhancement of gas pricing, which was the main issue between the party, was also pending before the Honorable Supreme Court. The Honorable Court may be pleased to grant a long adjournment. Advocate for the opponent had no objection if so-and-so was granted. The matter was heard by the Honorable Supreme Court with its judgment dated so-and-so. During the pendency of this, and now the order has become final, paragraph 6. During the pendency of this matter, before the Honorable, the Union of India with its circular dated so-and-so has been pleased to fix the price of 1,000 cubic meters of gas at 1,400 gas for blind plus so-and-so. Opponent has paid the applicant price of gas as fixed by the aforesaid circular with effect from, this may be noted, that on and with effect from 87, it's all in order. The opponent has paid the applicant price as fixed by the aforesaid circular with effect from 87, 30th January with certain unauthorized deductions and so on, which are also payable to the applicant. It is humbly submitted that as per the record of the applicant, the opponent owes the applicant a total sum of 1,800 crores, consisting of 108 crores principal plus interest thereon, as on 31/3/2002. And thereafter, for recovery of this amount, and the prayer we seen, page 114. This honorable court be pleased to direct the opponent to pay a sum of 1,800 crores plus interest thereon. There's no calculation given, no details given, neither in this nor in the suit. But be that as it may, that is on the. Wait, so therefore, this application is filed
Yes.
for recovery of sums receivable on account of the differential pricing
Ji.
till 87. So in 2003 itself, they're conscious of their rights. They know they're entitled to it, and it has nothing to do. It is absolutely an illusory argument which is sought, a creative argument that it is only pursuant to the government of India giving us permission. It is a body corporate, and I'll take my lords. Now how the ONGC Act also reads. It's a body corporate governed by the terms of its enactment. It's entitled to enter into contracts, and it does move an application in 2003. It does not wait till 2008.
Ji.
It's filed in 2008 saying government of India gave us permission. Thereafter, on 19/11/2004, GAIL issued a disconnection notice to ONGC. Now, this disconnection notice is in terms of the agreement. Though the agreement ended in 2000, GAIL issued a disconnection notice.
So because of the price difference, the next renewal never happened.
No, no.
The Supreme Court
It's-
decided,
Yes,
once it decided, thereafter also there is no renewal.
there's no renewal.
There is no.
There's no nothing.
Oh.
And GSFC, GAIL issues a disconnection notice, which is replied to. We say we have no contractual obligation with GAIL. All dues of GAIL have been paid. GAIL is not concerned. GAIL is finally giving us this notice for ONGC's dues. And that is our reply, which is at page 365, exhibit 99.
So under that fresh, there was this document we were just perusing minutes back, where
Yes,
they say that, if you don't pay those dues, we'll stop the supply.
we'll stop the supply.
So that,
Supply was also never stopped.
okay.
That supply was never stopped.
But under that document, was GAIL authorized to?
No, no, so we
recover
say-
dues from the earlier portion?
Under that document, if we go back to that document stipulates that you shall continue to be responsible or liable to make payment to ONGC for its past dues. So merely by entering into a correct interpretation is that merely by entering into a contract with us for a period from 94 to 2000 and including the earlier 2 years when we have supplied you, your obligation to pay ONGC is not obliterated.
Correct.
So obligation is one thing. Initiation of proceedings for recovery, the right to sue is a different issue.
Okay.
So your obligation does not get obliterated. They issue us a notice, GAIL issues us a notice, and our reply is very clear. We say at page 365,
Yes.
at paragraph 2, we would like just 2 lines from there. Volume 2, page 365.
Yes.
We note that in the letter under reply, you have demanded an amount of 118 crores as principal amount and rupees 2,000 crores as interest on the outstanding dues allegedly payable to ONGC in respect of a period prior to 92. Without admitting or acknowledging any matter or liability, we would like to point out that we have not received any such notice from ONGC. And thereafter, we also point out that in the court of the civil judge, civil miscellaneous application is filed by ONGC against GSFC regarding the reference to arbitration, etc. where you have prayed for the same thing. And in any case, the matter is challenged before the Honorable Court.
Yeah.
And the Honorable Court, with the order dated 24/12/2004, which is at page 367. 367
Yes.
and 368, is pleased to pass the following order.
Hmm.
In the peculiar facts and circumstances of the case, adjourned to so-and-so. In the meantime, respondent shall reply, Mr. Nanavati, senior advocate, appearing for the petitioner, has submitted that ultimately the central government has to take appropriate decision, and the matter is under consideration by the concerned Ministry Government of India. The learned advocate or respondent has disputed that the matter is under consideration. So here their stand is that no, there's nothing under consideration.
Hmm.
And this is in 2004.
Hmm.
Or any other department of the state of Gujarat, of the government of India.
Hmm.
So it is their specific stand that there is nothing pending before government of India.
Hmm.
So where would the question of government of India giving them permission in 2005 arrive? But be that as it may, the Honorable Court records that Mr. Nanavati further submits that the petitioners would like to explore the possibility of making representation to Government of India, more particularly Ministry of Petroleum and Natural Gas. He further submitted that the petitioner would make necessary representation to concerned ministry within a period of 3 days from today. He has further submitted that without prejudice, the petitioners will deposit an amount of 10 crores with ONGC in 2 equal installments. So a without prejudice payment, which is made in 2 installments, is construed to be an extension of limitation. And I'll take my lords to the line of judgments which say, n number of negotiations, letters, communications, none of it can extend limitation. My lords have also held that limitation stands extended with injunctions of the court.
Yeah.
So merely because a without prejudice payment is made,
Yes.
it is contended that one, you have admitted your liability, and therefore limitation stands extended. A without prejudice payment would not extend any liability. In any which case, the second tranche of this last amount stands to be paid on 7/1/2005. The suit is filed on 2/5/2008.
Ji.
On 22/6/2005, I read that communication where Government of India says that the issue between is commercial, it's
Commercial,
covered by
then
the,
you said as
you
per-
deal with it as per
Yes.
law. And that ultimately culminates into the suit being filed on 2/5/2008. This is how they have described the limitation. If I may once again go back. Yes. If my lords once again goes back on narration of facts before I take my lords to the law.
Hmm.
If each of their submission on the cause of action be seen, how does the, would my lords
You want
maybe
me to
just
go to
go
the
through
brief?
limitation, provision, 1 minute,
Yes, 14 and
14 and
law and limitation act.
just briefly, I'm sure my lords have examined it multiple times. Section 3.
Yes.
Bar of limitation.
Ji.
Subject to the provisions contained in section 4 to 24 inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. For the purpose of this act, a suit is instituted so and so, and relevant, if my lords be pleased to see. There's no setup here. Clause, Article 14,
3 years from supply.
3 years. The price of for the price of goods sold and delivered when no fixed period of credit is agreed upon 3 years
G. And from the date of delivery of the goods.
from the date of delivery of goods.
G.
From 87 onwards, the pricing is as per the Government of India's determination. And that has duly been paid. So for 82 to 87 is the disputed period. And if I once again trouble my lords to go through each of the events referred to, how none of them would stand to extend the period of limitation.
Which page is the plaint? That
Page
cause of action
30,
clause.
yes. And Milord, also relevant is effect of acknowledging in writing. They would be referring to section 80, which says,
18 and 25 of the Contract Act perhaps.
no, 18 of limitation.
Correct, but 25 is also a similar provision
Yes,
of the Contract Act.
correct.
So both will,
Where
In it.
before the expiry of the prescribed period, effect of acknowledgement in writing. Where before the expiration of the prescribed period for suit. So before 3 years, if the prescribed period is 3 years, before that prescribed period of suit, for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or the right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed.
G.
And also 19, effect of payment on account of a debt or interest on legacy.
G.
Where payment on account of a debt or of interest on a legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized in this behalf, a fresh period of limitation shall be computed from the time when such payment is made. Now, keeping these two provisions, the period of limitation being 3 years, gas pricing having come in 87, they are seeking to recover up from 82 to 87. From 92 onwards, it is GAIL which has entered into the contract, but the pricing is the same. Pricing is as per government pricing.
G.
So there is no dispute on the pricing. Even assuming that it is still 92, from 87 onwards, there is no difference. 87 to 92, pricing is not the concern. It's only from 82 to 87, the pricing is the concern.
G.
So your cause of action, whether it starts from 87 or you take 92, this present suit, in my humble submission, is hopelessly time barred.
G.
The cause of action for the suit arose at paragraph 30, page 13, paragraph 29. The cause of action for the suit arose when the agreement between the plaintiff and the defendant has been executed and the same expired.
G.
If the Honorable Court be pleased to note the date.
Yes.
It would be 25/12/81. 3 years therefrom would be somewhere 83. And it also arose when the defendant wrote a letter requesting for execution of an agreement. Pausing here for a moment, how does the present appellant's request, which is dated 1/12/79, that date, how does that communication requesting for an extension of the agreement extend the period of limitation?
Cause of action and extending would be different things.
Different.
G.
So he says my cause of action has arisen on all these dates. He's referring to the cause of action to point out that the suit is filed within the period of limitation. So my cause of action has arisen on all these dates, the last being of 2005.
Hmm.
Last being 2005,
Hmm.
where Government of India says you can go ahead.
Hmm.
And it also arose when MOPNG with a letter dated 22/6/2005 informed the companies to take action as per the terms of the contract.
Hmm.
Therefore, we have taken an action on 2/5/2008.
Hmm.
And therefore, it is within limitation.
Yes.
So, Milud, for each of those, if the dates be examined, neither would be the terminate. Your contract comes to an end in 81, after which there's no contract.
Hmm.
There comes arbitration, there is an order of the court. The order of the court is directing you to supply.
Hmm.
It is not precluding you from initiating any action for recovery of your dues. It says continue to supply. So the order of the court cannot be held to extend the period of limitation.
Yes.
This is not an order which precludes you from enforcing your contract. You're a body corporate.
Yes.
Thereafter, they say that, my lord, ultimately government pricing came. After government pricing, the Honorable Supreme Court determined the price.
Hmm.
And therefore, we believe we are entitled to receive with the determination of the Supreme Court.
Hmm.
Even assuming without accepting that the order of the Supreme Court
Hmm.
entitles you to receive at 2,000 or whatever be the amount you have determined,
Hmm.
it is of 1990.
Hmm.
From 1990, you have filed a suit in 2008. 18 years thereafter.
Yes.
Thereafter, the agreement between GAIL, they say the agreement between GAIL, you had agreed that you would continue to be liable for the past dues.
Yes.
Agreement with GAIL concludes in 2000. Pending the agreement, you do nothing. There is no communication at all. There is no notice, nothing. No suit is filed. Even notice does not extend the period of limitation. You file no suit. Your suit is only in 2008.
Yes.
Thereafter, GAIL issues notice. Pursuant to the notice issued by GAIL, this honorable court directs that you make payment, which is in fact, there's no direction. It is upfront, it is offered that to show our bona fides, we will make a payment of 10 crores in 2 tranches.
Yes.
This payment which you make
That
is
was
without
undertaken
prejudice.
before the High Court. I see.
Undertaken before the High Court. It is a without prejudice payment. A payment made without prejudice to show our bona fides would not extend the limitation, assuming even that date, the last date of payment which is made, this suit is filed even beyond that. 7/1/2005. This suit is filed on 2/5/2008. So by no stretch of imagination, my submission is either in facts or in law, can they contend that the present suit is filed within limitation?
Okay. What was the actual date or deposit of these 10 crores?
I've given those dates. The deposit of those dates in my chronology
To
is
be
that
made in 2 tranches, I
2
suppose.
tranches, yes. The last tranche is paid on, is paid on, last tranche is in my chronology, item 20, 7/1/2005.
Okay.
There is one more document I wish to place before the Honorable Court. That whilst ONGC earlier was under copies still? On and with effect from, there is a repeal act which says that the ONGC Commission into bracket Transfer of Undertaking and Repeal Act of 93, whereby the Commission Act stands repealed and the appointed date is 1/2/94. At the end of the page, if it be
Yes.
seen,
12.
it's referred to as 1/2/94 as the appointed date. So therefore, the ONGC Act comes into being. It always was a body corporate. It was referred to as the body corporate as ONGC Natural Gas Commission Act. Now it becomes the
2nd
ONGC.
July 93, no.
2nd July.
Very-
No, my lord. I believe it is
February 9.
1st February 94. So let me read. This act may be called as the Oil and Natural Gas Commission Transfer of Undertaking and Repeal Act of 93. It shall deem to have come into force on the 2nd day of July 93. In this act, unless the context otherwise required, appointed date means such date as the central government may by notification in the official gazette appoint under section 3. It comes into effect from that date, and that date is given as the 1st February 94, end of the
So
page.
why not under 1/2, as in 1 subclause 2? Appointed date must be for some other specific, section of this act. It may provide that on appointed date, such and such thing is to happen. The act
Yes,
would have-
act has come, I stand corrected. Act comes into effect on the 2nd of July 93.
Correct.
Appointed date is 1st February 94.
Appointed would be date for some other obligation,
Correct.
perhaps, for some other act.
Right. So herein after the act comes into being,
So from 2nd July, this
ONGC Act has come.
this
Yes.
repeal would have taken.
Repeal has taken place.
Yes.
And so the appointed date is for the purpose of section 3(1).
No, but repeal is
Section
only
3.
for this ordinance, repeal ordinance.
On such date as the central government may by notification in the official gazette appoint, the undertaking of the commission shall stand transferred. That is the date the act comes into effect
Okay,
from this, but on this date it stands transferred and to vest in the corporation.
which section is that?
Section
Oh,
3.
four.
3.
Okay, 3, okay.
So it stands transferred to and vest in the corporation.
But એ પાછી ત્રીજી date છે, not the appointed date.
No,
So
there is an
there's some-
there's an asterisk on top. And that
Yes.
asterisk is 1st February 94.
Okay. Very good.
So, my lord, I'm relying on this to point out that when Article 14 was referred to, it was their contention that they come under 1112, which means that they are under central government. Completely belied by the fact that even under the Commission Act, they were empowered to enter into a contract. They have filed an application in miscellaneous application number 83 of 85 of 82, where they are seeking recovery without recourse. The recourse to the central government by way of a note was made in 87 and
What about
90.
1112 you said? I'm sorry, I didn't get it.
1112, they referred to in their arguments
Ah.
before the trial court,
Ah.
they referred to Article 1112,
Ah.
which says any suit except a suit before the Supreme Court in the excise or original section.
1112 article of the constitution, you going to say?
Now,
Oh,
of Limitation Act,
112.
112. They say we have a limitation of 30 years.
Any suit except a suit before Supreme Court in excise of original jurisdiction.
By or on behalf of the central government or by any state government, including the government so and so. So they say we constitute the central government.
Just for clarification, I have not placed this submission. Probably it is recorded in the.
Okay,
I'm not.
so if it is not being
Not
pressed.
I'm impressed, I would.
Well,
I sent corrected. I was not before the trial court.
okay.
I go with what my friend says. So in view of all these facts, it is my submission that the suit is hopelessly time barred. And I'll now take my lords to the relevant judgments on this aspect. But
Yes.
we had given detailed submissions in writing, which constitute paper book 4. But would my lords want me to go through the chronology subsequently since the filing of the suit, how this issue comes to be decided as a preliminary issue? Should I
That I
complete that?
believe is a direction of Honorable.
Honorable High Court, yes.
And that has been.
That is how it is decided.
Well,
So if need be, I'll address on that, or I can still complete the,
does it have any bearing on, because it has been decided?
it
and
has been decided, yes.
That is not under dispute, so therefore, would
I'll
it?
read them.
Huh?
If she doesn't, I still will read them.
So then let me
Not
complete
very
it.
much. If she intends to, she may read it.
I will read
I
it.
in any case
Because
intend to
the-
read them.
No, I was just trying to focus on the controversy.
Right, because the reason I'm making this submission is, in the reply, they say the appeal is not maintainable.
Okay,
So I'm not sure whether that argument, if it were, it would have been a preliminary objection, in which case I would have dealt with it. But if it's not yet been taken, if I need to, I will deal with it right away. I can
very
deal.
well.
It's taken at the first available instance. Because I'll address your.
So if it's a preliminary issue, then they would have mentioned that a preliminary objection is taken on the
My
maintainability.
secretary would really require
But-
me to wait for my turn to come when she is done.
Very well, I'll complete it.
I will not preclude him from raising, I am just making
So
it very clear.
let me then deal with this
Very well.
on the maintainability also. Let me complete my submission on maintainability.
Very well.
Very well, let's complete the chronology, my lord. Thereafter, so my lord, ONGC files a suit. I'd taken my lords to the cause of action. A list of documents is filed in my details I've given, in my chronology details,
Ji.
at item 25. A list of documents is filed on behalf of ONGC. GSFC files an application under Order 7, Rule 11, Order 14, Rule 12, and or stay of the suit under Section 12, Section 10 of the Civil Procedure Code on the ground of limitation, or in the alternative to frame preliminary issue of limitation under Order 14, Rule 2, or in the alternative stay the suit under Section 10 of the CPC. This comes to be rejected, against which, my lord, the trial court passes an order below Exhibit 12, stating, which is at page 37A, paper book 1.
Sorry, 1 minute.
Nothing. 37A.
Ji.
After referring to all the facts. This is the order which is passed. Paragraph 12. Page 37M. Thus, it is evident ratio of this judgment that plea of limitation is a mixed question of law and facts. But it depends upon the facts and circumstances of the case. In the present case, the facts are complicated, which cannot be decided without oral and documentary evidence. Therefore, in the present case, the question of limitation cannot be decided without appreciating oral and documentary evidence. I have also considered the judgment of the High Court in the case of so-and-so, wherein the Honorable High Court has held, when the suit is barred by limitation on plain reading of the plaint, it is required to be dismissed under Order 7, Rule 11. The suit cannot be brought within the limit by clever drafting or submissions. In the present case, from perusal of fact reveals that the suit does not prima facie appear to be time-barred. And the present case, the plea of limitation can be decided only after recording evidence. I have also considered the following judgments. In all the judgments, there's a consistent view of the Honorable High Court that the plea of limitation is a mixed question of law and facts, and therefore it can be decided only after leading oral and documentary evidence. Therefore, these judgments are not decided in view of plea of limitation cannot be decided as at a preliminary stage. This order is challenged before the Honorable High Court. And at page 50. At page 50,
50.
50. Learned senior advocate for the applicant states that he does not press for the present revision application. However, the applicant be granted a liberty to make a fresh application, requesting the trial court to decide the issue of limitation as a preliminary issue, as though the prayers were made by the defendant in the application below Exhibit 12. The said prayer has not been considered by the trial court. Learned advocate Mr. Ajay Mehta for the respondent has no objection if permission as sought for is granted. And accordingly, the Honorable Court, in view of the above, permission as sought for is granted, present revision application is dismissed as not pressed with liberty prayed for. It is needless to say, if such application is made by the applicant defendant seeking prayer to decide issue of limitation as preliminary issue, the same shall be decided by the trial court in accordance with law. Thereafter, GSFC filed a statement which is on 5/5/2017. Written statement is filed. And an application is preferred, permitting it to lead evidence. The Honorable Court rejected the said application, taking a view that since the issue of limitation is already framed as a preliminary issue, which is on 24/12/2017. Take a separate copy of that. Oh. The Honorable Court rejected the said application by taking a view that since the issue of limitation is already framed, the above mentioned application becomes infructuous to frame the preliminary issue of limitation. Thereafter, an affidavit in chief is filed by ONGC. Cross-examination of ONGC's witnesses. The present appellant prefers an application for permitting to lead evidence at a later stage, as the issue of limitation framed as issue number 8 was to be proved by the respondent herein in the above referred commercial suit. The Learned Commercial Court rejected this application also. Being aggrieved, we prefer special civil application 112686. Now, this order decides. Lord, if my lords be pleased to turn to page 230. Page 230.
Yeah.
There shall be a formal notice of the petition on so and so, so and so. By way of the petition under so and so, the original defendant has prayed for an approved writ order direction to quash and set aside the impugned order passed by the Learned Judge Commercial Court Vadodara below Exhibit 63 in commercial civil, by which the application submitted by the applicant, original defendant, to permit it to file affidavit of evidence only after preliminaries issue is decided. So the trial court had said, you file your affidavit of evidence, to which we said a preliminary issue on limitation, because our valuable right, our whole case is founded that your suit is hopelessly time barred. We believe it is beyond limitation. And therefore, it is a case where limitation must be decided as a preliminary issue. We have heard learned senior advocate appearing on behalf of the petitioner, Mr. Shri Ajay Mehta, a learned advocate appearing on behalf of the respondent, plaintiff. It is not in dispute that as per the earlier order passed by the Learned Commercial Court, the issue with respect to limitation is to be decided as a preliminary issue. It is also not disputed that the question of limitation is a mixed, it's not mistaken, it's a mixed question of law and facts. And therefore, even for the purpose of deciding the said issue as a preliminary issue, parties are required to lead evidence. And therefore, there is a broad consensus. This is relevant. Both parties are at idem between the learned advocates appearing on behalf of the respective parties, that the parties may lead evidence at the earliest, and thereafter, before the suit is further proceeded, on the basis of the evidence that may be led, Learned Commercial Court to decide the issue with respect to limitation as a preliminary issue. And subject to the outcome of the same, the learned judge may proceed further with the suit accordingly. The learned advocates appearing on behalf of the respective parties have assured the court that both the parties will complete recording the evidence within a period of 2 months from today, and thereafter the party shall give a closing pushes the learned commercial judge to decide the issue with respect to limitation as a preliminary issue, as ordered earlier on the basis of the evidence that may be led, and after proceed further with the hearing of the suit, subject to the decision on the issue with respect to the limitation at the earliest. So, my lord, it is directed to be considered as a preliminary issue. Accordingly, if the order impugned be seen, just the title. The order impugned refers to the title.
Basically, both of you agreed there.
It
And
was
therefore
in
this-
idem, and therefore the honorable court notes that it is an order passed pursuant to the order passed by the honorable court deciding the limitation.
There it says order and direction given in this
Orders
petition.
and direction given in writ petition which is produced on record with the exhibit. I have to decide issue number 8 of exhibit 30 as a preliminary issue. It's decided as a preliminary issue. My lord, if the order impugned be seen, it is a judgment which is passed after considering the issue of limitation as a preliminary issue, just the structure. There is oral evidence, there is documentary evidence, exhaustive, as many as 200 plus. 202 documents supplied, depositions, cross-examinations, 221 documents. And issues framed, written arguments considered, relevant propositions of law considered, and thereafter is the verdict. In my submission, it is not about trappings of a judgment, it is a judgment. It is a judgment after a full-fledged trial. You know, section 13 of the Commercial Courts Act.
Commercial court. You may read. You may read, I'll follow, not a problem. Everybody is- Ah. Yes.
Section 13.
Appeals.
Appeals from decrees of commercial courts and commercial divisions. Appeals from decrees of commercial courts and commercial division. Any person aggrieved by the judgment or order of a commercial court below the level of the district judge may appeal to the commercial appellate court within a period of 60 days from the date of the judgment of
I
the
was a
order.
commercial court judge for 3 years. It is at this stage that I realized that this is providing an appeal from a judgment as against a decree.
Yes,
The
yes,
title says decree,
yes,
but
but
strangely it says.
but the text
But
is judgment.
this is very odd, you know, it is
Yes.
not as
Sometimes,
specific.
what happens is that during the legislative process of resolution, sometimes the title or the chapters are couched in a way where ultimately the honorable apex court has interpreted them in various other statutes.
Characteristics na ख्याल आया, but anyway, we were not to
Yes,
decide any appeals as per se, but
correct.
this is very strange provision.
Yes, it is.
Because the title refers to something else as decree and then there was the
It should have been decree, but it is
judgment.
there as
Yeah.
judgment.
Earlier provision prior to 2015 was any finding also. Now in 2018, the amendment comes where there was the words adopted instead of finding. Is now
Yes, yes.
converted to order and judgment.
So judgment ordinarily, my lord, 96 would be judgment and decree. We now have even order.
Ji.
So any person aggrieved by judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of the judgment or order. 1A is not relevant for our portion, provided that an appeal shall lie from such orders. So if you are referring to order, then it has to be such orders passed by the commercial division or a commercial court that are specifically enumerated under Order 41 of the Code of Civil Procedure.
43.
43.
I'm sorry, Order 43. So under Order 43, those that are enumerated would fall within the definition of order. This is why we believe perhaps initially that we under Section 8, if my lords also be pleased to see Section 8. Bar against revision application or petition against an interlocutory order. Notwithstanding anything contained in any law for the time being enforced, no civil revision application or petition shall be entertained against any interlocutory order of the commercial court, including an order on the issue of jurisdiction, and any such challenge subject to the provision of Section 13 shall be raised only in an appeal against the decree of the commercial court. So therefore, we believe that perhaps since Section 8 rightly so, that if for everything you keep going up to by way of appeals, then there is the trial would never come to an end. Therefore, it bars it. There is a judgment of the Honorable High Court where the Honorable High Court says remedy cannot be completely ousted. Therefore, 227 at least would be maintainable. But therefore, we preferred a civil revision application when special civil application. When special civil application was taken up, would my lords be pleased to see the order passed, which is at paper book 5, the last. In fact, in my delay application, I had referred to it. Or paper book 5, the last order. Last.
Yes.
The challenge in the instant petition filed under Article 227 of the Constitution of India is to the findings returned by the commercial court on the question of limitation decided as a preliminary issue on the evidence led by the parties. When the dispute pertaining to the maintainability of the instant petition under 227 of the Constitution is raised, because this was the objection, that how would it be maintainable? It is a full-fledged trial conducted, documents, evidence, cross-examination. How would a writ petition be maintainable?
Yes.
When the dispute pertaining to the maintainability of the instant petition under 227 is raised, as the challenge is on the merits of the order passed by the commercial court, learned counsel appearing for the petitioner requested that the petitioner be permitted to withdraw the instant petition as it proposes to prefer an appeal under Section 19 of the Civil Procedure Code, read with Section 13 of the Commercial Courts Act. In view of the above statement, the present petition is dismissed as withdrawn as the petitioner proposes to challenge on merits. We said very well. They are right. It has all the trappings of a judgment. It is a judgment. It is after a full-fledged trial. It conclusively decides the rights of the parties. There is a finality to it. And the injury is not illusory. I lose my right if I do not challenge it here. My submission.
So this can be a submission.
My submission.
You can put it in High Court.
No, I'm not putting it in High Court's mouth.
This is not finding.
This is my submission. Having
I know what the
accepted,
order is, so therefore, yes.
so having accepted that, having considered what they are saying is correct, we withdrew it. When the matter was taken up for delay condonation before the Honorable Court, would my lords be pleased to see the order passed?
Yeah.
The present application filed under Section 5, read with Section 14 of the Limitation Act, etc. The brief facts. Heard learned counsel appearing, submitted judgment in question came to be delivered, so and so, so and so. Paragraph 5. I have given the same explanation which I've given, my lords have recorded. That within the period of limitation, we have preferred it. We moved the High Court within 27 days. Till then it was pending. And in view of Section 14, this time be excluded. Paragraph 5. Learned advocate, Mr. Kedar Biniwala has vehemently opposed this application, submitting that the revision proceedings cannot be said to be bona fide proceedings before the Honorable High Court. It is apparent that the order impugned is having all the trappings of a decree, and the applicant should have construed it so, and thus filed an appeal at the outset before approaching the High Court. So it is their contention, which the Honorable Court records, that we should have come here. It is their submission that we should have come here. When we moved to 27 before the Honorable High Court, they opposed it. They said no. Having opposed it on the ground that it is not maintainable, here it is the specific case that we ought to have come by way of an appeal. It is their submission. And today, if the argument is to be canvassed that appeal is not maintainable, it is not tenable because the very submission of the counsel for the defendant of the opponent has been recorded, that we should have come by way of an appeal, and therefore you are pursuing a wrong remedy. It is apparent that the order impugned is having all the trappings of a decree, that the appellant applicant should have construed it so, and thus filed an appeal at the outset before approaching the Honorable High Court. It was thus submitted that once the proceedings are held not to be bona fide, exclusion of the period spent in litigation, the matter before the High Court cannot be made for computing the period of limitation, and that therefore the delay becomes too large to be condoned. Accordingly, it was submitted to dismiss the present application. Learned advocate also requested that the court may please grant him time to file and reply for so and so, so and so. Thereafter, the Honorable Court is pleased to condone the delay. So, before the Honorable Court also, it is their submission that the appeal is maintainable.
Yeah.
My lords have had an occasion to examine this definition of judgment n number of times. Just for my satisfaction, if I may be permitted to read. 2.9. Judgment means a statement given by the judge of the grounds of a decree or order. It is a judgment, there's no doubt. 13 talks of judgment and order. Order is, there is a proviso which says that which falls under order 43. But there is a direct judgment of the Honorable Supreme Court which says order 43 is not exhaustive. If it has the trappings of a judgment, it is appealable. Yes. And of course, there are many more such judgments. I'm just citing one illustratively. 2023, one Supreme Court cases, 634. Relevant paragraph 19. It has been held in Shah Babulal Khimji that most of the interlocutory orders which contain the quality of finality are clearly specified in clauses A to W of Order 43, Rule 1 CPC, and would be judgments within the meanings of letters patent and therefore appealable. However, there may be interlocutory orders which are not covered by Order 43, Rule 1 CPC, but which also possess the characteristics and trappings of finality, inasmuch as such orders may adversely affect valuable right of the party or decide an important aspect of the trial in an ancillary proceeding. It is further been held that, however, for such an order to be a judgment, an adverse effect on the party concerned must be direct and immediate rather than indirect and remote. We have been adjudicating that limitation, this whole suit is barred. They do not have a right to sue, and therefore the suit be dismissed on the ground of limitation. My very valuable, it's a direct injury, direct and immediate rather than remote. Various illustrations of interlocutory orders have been given by this court in Babulal Khimji, which would be held to be appealable. This court in Shah Babulal Khimji held that though any of the suit may cause some inconvenience or to some extent prejudice to one or the other party, cannot be treated as judgment unless they contain the traits and trappings of finality. This judgment is is a judgment. It does not, I don't need to go as far as to say it contains a traits and trapping. It is conducted, a full-fledged trial is conducted.
Ji.
And when I make my submissions on law, I will take my laws to various depositions also, where they have admitted that the central government never precluded them from preferring filing of the suit. This court has expressed in para 122 that all that of Babulal Khimji, that though it had by way of sample laid down various illustrative examples of an order which may amount to a judgment, it would not be possible to give an exhaustive list that may cover all possible areas. So it's not just those which are referred to under Order 41, 43, Rule 1. It's not exhaustive. Babulal Khimji is 81. Just for the reference of the Honorable Court, Babulal Khimji, it's referred to, but
Ji.
paragraphs 111 onwards, I'm not reading it. Relevant is extracted, but I rely upon paragraph 113, 15, 16. If I may be permitted, at page 55, there is some discussion which would bear some relevance. Page 55. The citation is 1981 for Supreme Court cases 8.
Final judgment, preliminary judgment.
Final judgment, preliminary judgment. Part B of preliminary judgment. Another shape which a preliminary judgment may take is that where the trial court passes an order after hearing the preliminary objection raised by the defendant relating to the maintainability of the suit, bar of jurisdiction, res judicata, manifest defect, absence of notice under 80 and the like. And these objections are decided by the trial court against the defendant. The suit is not terminated but continues and has to be tried on merits. But the order of the trial court rejecting the objection doubtless adversely affects the valuable right of the defendant, who, if his objections are valid, is entitled to get the suit dismissed on preliminary grounds. Thus, such an order, even though it keeps the suit alive, undoubtedly decides an important aspect of the trial, which affects the vital rights of the defendant and must therefore be construed to be judgment so far as appealable. Larger.
Any issue which is has a directly bearing or dismissal of the suit
Yes.
would be the.
Yes.
Okay.
Yes. So is the injury direct and immediate, or is it at a distant point of time? Is your valuable right being affected? Is it a statutory right you have, which the law confers upon you? Those aspects. So therefore, insofar as the contention on the maintainability is concerned, my submission is, if the provisions of Section 13 of the Commercial Court Act is seen, in the context of their submission before the Honorable Court, in the context of the admission of their submission before the Honorable Court, when we preferred a writ petition, where they raised an objection on maintainability. And before the Honorable Court submitting that the appeal is the correct remedy, which they ought to have availed of, which we have availed of. And this order passed by the Honorable Court is not challenged. This order is accepted. And therefore, we are before the Honorable Court. There is no question of this appeal not being maintainable. The term used in Section 13 is judgment or order. And this definitely is after a full-fledged trial. There is finality to it. It decides the rights of the party. My valuable right gets infringed, which in view of the provisions of Section 97 of the Civil Procedure Code, if I do not challenge now, I lose my right. Section 97. Appeal from final decree where no appeal from preliminary decree.
Yes.
Where any party aggrieved by a preliminary decree passed after the commencement of this code does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. My lord, if I do not challenge that this suit is barred on limitations, and I permit the suit to proceed further, I lose my right that it is barred on limitations. My whole case is that this suit cannot proceed. The statute has prescribed a period of limitation of 3 years. This suit on the demurrer, on going through the various causes of action as stated, once again, I'll take my note. None of those would stand extending the period of limitation. If period of limitation does not get extended, and if the suit stands to be barred, then my valuable right of having the suit being rejected on the ground of limitation is lost. My lord, if my lords be pleased to turn to once again their cause of action. Just briefly, if the dates be seen. Which of those dates could even be considered to extend
Yes.
the limitation so that factually we stand completed here? The cause of action for the suit arose when the plaintiff and defendant executed an agreement and it expired in 81. 3 years thereof, here the suit
83.
is filed on 2008. When the defendant wrote a letter requesting for execution of an agreement, this was 79 prior thereto. Again, 3 years thereof would be 82. When the defendant served the plaintiff a notice intimating the appointment of an arbitrator, which is 2382. 3 years thereof would be 85. It also arose when the defendant by letter of the advocate informed that the arbitrator will act as the sole arbitrator. This is 24,382. It also arose when the plaintiff tried to resolve the issue amicably, and also arose when the plaintiff filed application number 85 of 82. So it is in 82. 16,482 is when the application was filed. 16,482.
Yes.
Before the civil judge Vadodara, challenging the appointment of the arbitrator, and it also arose when the pushes was filed by the plaintiff and the matter against stoppage of gas supply to the defendant. It also arose when the Honorable Court in CMA 8582 passed the order to stay the said petition. Pausing here for a moment, the date of that order is 16,482. That order, as I read before the Honorable Court, I'm not referring to it again.
What was the date again? Date of the order?
16,482. This order says that you continue the supply of gas. It does not preclude you from filing a suit. It says you continue to supply gas. We are staying arbitration proceedings. The court neither had the jurisdiction, nor was there any prayer with regard to any contractual matter. It says you file a pursuit, you continue to supply gas, and we will direct the present appellants not to proceed with arbitration, though there may be a dispute regarding the same. It also arose when the government of India fixed the price at 3187. Correct, they're right. So when government of India has fixed the price at 1400, that at least was a stage when you ought to say that for a period prior thereto, because from 3187, we have been paying as per Government of India norms. So prior thereto, my dues are unpaid, and the period thereof would be 1990.
Yes.
It also arose when the Supreme Court by judgment dated upheld the price fixed by the petitioner.
This fixation of price by the government, what was the date on which it was? fixed?
Yes, it was fixed on 3187.
No, that is the effect that has been given. 87 is the effect from which it
Yes,
has
it
become.
is fixed in 1990. It is 1990. I'll take my law student document.
No, that you have already done. I just wanted to
I believe it's
recollect.
87 only. But eight, 3187, it is correct. 3187.
ત્યારનો લખો ને એ જ દિવસ.
ક્યાંનો લખો એ દિવસ? એ દિવસ.
એવુંમાં ખાલી નામદાર સુપ્રીમ કોર્ટે કન્ફર્મ કર્યું કે
ઓકે.
રાજભાવ રહેશે.
ઓકે.
બધાએ આપવું પડશે. તેના આપવું હોય, બાકીના આપવા દાવા.
જી.
It also arose when the Honorable Supreme Court upheld the price fixed. That is 1990. 3 years thereof would be 1993.
Yes.
It also arose when the issue of recovery of dues of the plaintiff from the fertilizer company was submitted to the central government. Now, I've taken my laws to those documents. They have submitted, when Government of India fixed the price on 3187, it also called from them a note. Give us a comprehensive note of how much are your dues and pending from whom. So according to them, our filing of this note before the Government of India extends the period of limitation. Your submission before Government of India, in my humble submission, would by no stretch of imagination extend a statutory period of limitation,
બરાબર.
which is dated 5/5/87 and 24/4/1990. N number of communications may ensue. N number of communications may ensue, and I'll take my laws to the judgment of the Honorable Supreme Court that negotiations and communications between between the parties does not extend period of limitation.
Gail never submitted this note, right?
No, Gail never submitted.
Gail came into picture much later.
Gail came
Gail was, their submitted is.
For that, those 6 years.
6 years, yes.
So they come into picture much later,
94 to 2000.
Yes, and it has altogether a different purpose to be achieved so far as scale is concerned, not like ONGC. So it is only distribution business.
Marketing is transfer.
Marketing,
Ji,
etc.
ji.
So not concerned with generation or anything else.
Yes.
But their submission is this. It also arose when Government of India handed over the gas marketing to GAIL.
Ji.
And it also arose when the agreements were executed between GAIL and the defendant, which was for a period between 1990 to 2000. That contract concluded in 2000. And also arose when GAIL issued a letter to the defendant for payment of plaintiff's dues. It also arose when the defendant filed special civil application before the High Court of Gujarat, and it also arose when the defendant deposited 10 crores towards the dues of the plaintiff. This was a writ petition in which, without prejudice, a payment is made to show bona fides, which also is of 1/7/2005, that second trench which the Honorable Court wanted to know.
Ji.
This 10 crores is also
Correct.
2005. 7/1/2005, even beyond. And then this is what they say is the final, where it stands extended. The cause of action arose when MOPNG with its letter dated 22/6/2005 informed the companies to take action. Milord, it is clever drafting. And I say this because they do not mention the application which they moved in the 85 of 82, where they are seeking recovery of the dues in 2003. So not only are they aware of their rights, they have endeavored to recover their rights. They have moved an application, though there are no details given of how they've computed, neither in the plaint nor in that civil application. They have given a figure that we pray for this unpaid dues of this extent. So in 2000, to say that we are waiting for Government of India to give us the approval is belied by their own conduct. In 2003, they do move. Of course, that application eventually is dismissed in 2010, where the Honorable Court holds that this matter has now become infructuous because you filed a substantive suit. So there's no question of considering any of this. Plus, this was an application filed for arbitration, stay of arbitration proceedings. Where is the question of considering your recovery? No, lords want to see that order.
Volume.
The 2010 order. Yes, it's Exhibit 51, page 170. On read the
Yes.
read the plaint, etc. All of it, order below the application at Exhibit 5 and the application at Exhibit 23 in civil miscellaneous application, number 85 of 82. And the Honorable Court goes on to hold the exhaustive order, but it goes on to hold at page paragraph 5, page 122. The opponent, Gujarat State Fertilizer Corporation, has submitted their reply at Exhibit 28 to an application below Exhibit filed by the appellant, whereby it is contended that the contents and statements made by the applicant in this application are not admitted and wholly denied. Thereafter, somewhere in the middle of the page, it is further submitted that the present application filed by the applicant for recovery of the alleged amount from the opponent is beyond the prescribed period of limitation. We put limitation to their notice also. The applicant made an attempt to do a particular act which is otherwise time barred. The applicant has failed to file substantial proceedings before the competent court of law for recovery of the alleged amount as mentioned in this application. Pertinent to note that the amount paid for by the applicant at para 9 shows that relying on the order of Supreme Court of India, the applicant wants to recover the amount of the opponent and further with interest from so-and-so. The time-barred claim of the applicant deserves to be dismissed with cause. It is further submitted that proceedings under the Indian Arbitration Act for stay of arbitration procedure relief, prayer for recovery of money claim cannot be made by the applicant. The provisions of Section 33 in no way give a legal right to the applicant to pray for a relief against the opponent for recovery of the alleged amount. Since no cause of action survives between the parties, therefore present CMA has become infructuous, deserve to be dismissed. It is further submitted that the applicant below Exhibit 23, filed by the applicant, do not disclose the cause of action and it is effective date for enforcement of recovery. It is the proceedings under the Indian Arbitration Act. A relief of the nature of money decree cannot be prayed for by the applicant without making so-and-so, so-and-so. And thereafter, finally, the order, my lord, the Honorable Court, considering everything, is pleased in para 10. My lord, page 132, last 10 lines.
Yes.
Neither the issue of renewal of the agreement, nor the supply of gas, nor the price of gas is subject of this application under Exhibit 5. So looking to the written arguments addressed by the opponent side, I'm of the agreement with the stand raised by the opponents, and further looking to the factual aspects narrated in the written submission as the earlier injunction order was limited period. It is not a fit case to extend such injunction order for an indefinite period. Therefore, I am the opinion that such injunction requires to be immediately vacated. As far as application Exhibit 23 is concerned, I have referred to written submission made by the concerned parties of the civil miscellaneous application. In this application, the applicant had pledged that the opponent should pay a sum of X crores plus interest. It is to be noted that the present application Exhibit 1 in civil miscellaneous application is not a suit for recovery of any amount. No court fee stamps are affixed for recovery of such amount. Moreover, the question of limitation is being raised by the opponent side. Further, pushes exist relying on which the interim injunction order is being passed by the court. Such pushes is filed by the applicant itself and not by the opponent side. It transpires from the written arguments given by the opponent side at Exhibit 62 that in May 92, the applicant handed over the task of marketing to Gas Authority of India, and from May 92, the applicant ONGC is not supplying gas to the opponents. So recovery of any amount or any order of such recovery cannot be passed without affording an opportunity to concerned parties regarding the supply of gas. Moreover, the dispute, when the applicant has really an enforceable claim against opponents for recovery of the other difference of price, is in respect of the period from April 82 to 87, is also pending adjudication before the Honorable High Court. Moreover, for such recovery, applicant has also filed a special suit, being 181 of 2008, where the opponent has raised a plea of limitation, apart from contesting on merit. Thus, the claim is already subject matter in two proceedings, and therefore the Honorable Court says I'm disposing of it.
Can you just remind me what this CA 1580-8849 of 2004
Just
was?
a minute, I just, 1 minute.
Challenge.
It is a challenge to the notice of,
Yes, yes, okay, I got it.
Question was done, they challenged it, not saying that this can't be taken. Where the litigation reached up to honorable level. It is that, the nature there. Just to pass
Challenge
it
to,
on.
yes, yes,
One
fine.
look, any notice challenge,
That is what I'm going to.
any notice.
Okay. So how that litigation.
Lord, I'd like to rely on one judgment of the Honorable Supreme Court, the recent judgment.
Yes.
Device. Please. Lord, although, my lord, it's examining limitation in the context of arbitral proceedings, it is deciding on arbitration, how, on limitation, how, my lord, negotiations, communications does not affect limitation. Para 45, if my lord.
Are you referring to 24-5 SCC?
24-5 SEC, 358, I'm sorry,
Oh.
BNTAG,
Ji.
Ministry of Defense.
Ji.
Paragraph 45. The aforesaid observation makes it very clear that what is important for the court is to find out what was the breaking point at which any reasonable party would have abandoned efforts at arriving at a settlement and contemplated referral of the dispute for arbitration. The learned counsel appearing for the petitioner has placed strong reliance on para 28 of Geo Miller to fortify a submission that the breaking point was sometime in September 2019 and not 2016, as asserted by the respondent. What was the breaking point is a question of fact, and we shall deal with this issue later. However, para 28 referred to above should be read along with the observation made by this court in para 21 of the judgment in Geo Miller. Applying the aforementioned principles to the present case, we find ourselves in agreement with the finding of the High Court that the appellant's cause of action in respect of arbitration application number so-and-so relating to work orders of 79 and 80 arose on 2/3/83, which is when the final bill handed over to the respondent became due. Mere correspondence of the appellant by way of writing letters, reminders to the respondent subsequent to this date would not extend the period of limitation. Hence, the maximum period during which this court could have allowed the appellant's application for appointment of an arbitrator is 3 years from the date on which the cause of action arose, that is 8/2/86. Similarly, with respect to arbitration application number so-and-so relating to the work order of 85, the respondent has stated that the final bill was handed over and became due on 89. This has not been disputed by the appellant. Hence, the limitation period ended in 92. Since the appellant served notice for appointment of arbitrator in 92 and requests the argument before the court only on the end, his claim is barred by limitation. So issuance of notice does not extend limitation.
Mere correspondence or
Mere
fine.
correspondence, all of that does not extend limitation.
Right.
Thereafter, paragraph 73 and 74. Negotiations may continue even for a period of 10 years or 20 years after the cause of action has arisen. Mere negotiation will not postpone the cause of action for the purpose of limitation. The legislature has prescribed a limit of 3 years for the enforcement of a claim, and this statutory time period cannot be defeated on the ground that the parties were negotiating. In Pachu Gopal Bose versus Port of Calcutta, this court has held that the provisions of the 60-year would apply to arbitration notwithstanding any term of the contract to the contrary. Cause of arbitration for the purpose of limitation shall be deemed to have accrued to a party in respect of any such matter at the time when it should have accrued, but for the contract. Cause of arbitration shall be deemed to have commenced when one party of so-and-so, so-and-so, so-and-so. Delay defeats one. So, Milord, your hardships, your difficulties, all that. And thereafter, Milord, in para 75, the Honorable Court refers to Pachu Gopal again, paragraph 10, Placetum B, paragraph 75.
G.
The period of limitation for commencing an arbitration runs from the date on which the cause of arbitration accrued, that is to say, from the date when the claimant first acquired either a right of action or a right to require that an arbitration takes place upon the dispute concerned. Therefore, the period of limitation for the commencement of an arbitration runs from the date on which there has been no arbitration clause or cause of action, just as the case of actions or the claim is not to be brought after the expiration of the specified number of years from the date on which the cause of action arose. So, in the case of arbitrations, the claim is not to be put forward after the expiration of the specified number of years from the date when the claim occurred. But may I conclude? May I continue post recess or some other day? I'm okay to continue.
Yes, please continue.
Oh, okay. So very
I
We
think we are at
continue, we
1:30, Aditya. Let
Very
it be
well,
till
we'll
2 o'clock. Yeah.
It probably read by our Gujarat High Court's timetable that 1:45 your losses must be rising. Here the court timing is up to 4.
2 o'clock. I'm
2
sorry.
o'clock.
So possibly
So
you are
I went-
mistaken because of that. Anyway.
Yes, anyway.
I was also taken aback. मैंने तो अचानक से कह गया.
Uh,
I thought somebody,
Okay,
I thought somebody from here may have indicated to you or something. I એટલા માટે.
મને એવું થયું કે time થઈ ગયો છે before I start with the
ના ના
judgments.
જી.
You know, we have given exhaustive written submissions before the trial court,
જી.
which is also part of the paper book, which is at volume 4.
પોરાના નીચે જગ્યા. અહીંયા sorry. જી.
Not beyond the facts. So, my lord, if my lords be pleased to see, page 1071.
Yes.
Where, my lord, each of the dates which they have referred to, we have dealt with. It is submitted that the claim raised by the present suit is filed inter alia for the supply of gas made by the plaintiff to defendant between 82 to 87. Admittedly, this said supply was made without any contract between the parties. Moreover, invoices exhibit 114 to 117 issued by the plaintiff also did not provide any credit period for the defendant to make payment. Under such circumstances, Article 14 of the schedule prescribes 3 years, and thereafter, my lord, we relied on Southeast Asia. The reason I'm referring to that, we don't need to go everywhere to the judgment, just the relevant is extracted.
Now,
Southeast
before
Asia,
we deal with the case laws that or written submission of your on your end, we'll just go through the judgment
very well.
and line of the judgment so that we
So,
understand as in
yes.
what, then you could tell the portion where you have a dispute kind of.
Correct. So, my lord, paging. One of the paging.
You can refer to internal page number.
Internal page numbers are there.
That will be convenient for the.
So it will be internal page number 2.
Ji.
Clearly shows I haven't had too many opportunities to appear before the honorable court.
Yeah, am I taking so drastic a deviation that you feel? there's
No,
Okay.
no. Just that we are very used to running paging, na?
I see.
Like,
Okay.
so
Ji.
running paging is what I was asking my colleague, that
Ji,
where
ji.
is the running paging issue? He said,
Since we are accustomed to driving area levels, internal pages always makes sense.
Ji.
so because we usually have start every run page, na? But
Yes.
like. So, my lord, just, so we have heard so and so appearing on behalf, first page 2, appearing by so and so,
I think those introductory facts we can.
we
take.
let it go, my lord. And
Just go the
I
fact that
just
these-
want to take my lord briefly to the structure.
Ji.
That's why. Oral evidence, documentary evidence.
Ji.
And just so that once it, just to reaffirm the structure.
Yes,
Then again, oral evidence, documentary evidence. Thereafter, my lord, issues, written arguments. The reasoning. The reason-
possibly the court has gone by this running and continuous account, is it?
That's right, that's right.
So why, a line of reasoning,
A
you
line
said,
of
let me
reasoning,
know
let
as to where you have dispute, as in why
Yes,
you would
yes,
not be a running and
Correct.
continuous account.
correct.
Because at every paragraph or argument, the findings are recorded, not like unlike you know separately recording findings.
So
Okay.
the reason,
So submissions and this thing have been
And
clubbed.
then immediately you the reasoning by the way.
Oh, oh,
Is the style of the words.
the learned advocate for the defendant. So let me take on issue of limitation.
which.
We got
page are you-
internal page 13.
1-3. Ji.
The learned advocate for the plaintiff has written agreements. The learned advocate argued that ONGC was formerly known as ONGC Commission and was a body corporate having perpetual succession, common C. It is established that under the ONGC Act, Commission Act, it was directly under the Ministry of Petroleum and Chemicals, so and so. Transfer of Undertaking Act came. The capital of ONGC Gas Commission stood vested in the corporation, including all assets, rights, powers, authorities, privileges, and all properties movable, immovable, including contracts, deed, bond, guarantee, and any proceedings or cause of action pending or existing. The plaintiff, despite being converted into a limited company under the Companies Act, is and continues to be a government company under the aegis of the Ministry of Petroleum and Natural Gas. The advocate for the plaintiff further argued that ONGC is mainly engaged in oil and natural gas development, production, supply of crude oil, natural gas, besides production and supply of value-added product like so-and-so. Plaintiff and the defendant entered into an agreement. Thereafter, I'm not going through those factual narrations. Straight away, page.
The reasoning
So, Mil-
starts at 31.
Yes, but Milord, arguments are starting at page 50 from
1-5.
1-5.
Emma,
Yes.
record, basically they are by and large the same thing that you have already pointed
Yes,
out.
but just
Ji.
plaintiff argued that for the purpose of extension of agreement, no further agreement was signed and agreed upon between the parties. Advocate for the plaintiff argued that the defendant's advocate by notice dated so-and-so. This is their arguments that as the arbitrator calling on to upload was declared as sole arbitrator. The advocate for the plaintiff argued that notice dated so-and-so. Defendant's advocate informed that the defendant appointed so-and-so to act. Again, Milord, all this I have more or less argued.
Yes, yes. You may go through the reasoning at page 31.
31. The learned advocate for the defendant has cross-examined the witness of the plaintiff with the exhibit 30. A.T. Caliban, so-and-so, Deputy General Manager ONGC, which is done by the defendant.
Basically, pleadings cannot be, run across with by evidence. If it is there not there in the pleading, it cannot be
Correct.
supplemented by evidence. Evidence basically would be an extension of how the pleadings would have,
Correct.
can be
Correct.
proved.
Correct.
So, kadaach prashna jawab mein bhi, unless it is there is something very important, we'll just go to the reasoning as in how, on what basis the
So,
court
Milord, the relevant questions.
construes it to be
Correct.
fellow. A reasoning જોઈએ court में.
Because it is a specific point in our submissions
जी.
where we have questioned them.
Hmm.
That did central government preclude you from entering, filing a suit?
So
This
two
was
aspects.
spec-
One is that because acknowledgement 14 નીચે હોય અથવા તો પેલા not 14 પણ તમારું acknowledgement of date 18 ની નીચે
18 teacher.
અથવા તો 25 after the period of that
Correct.
beyond 3 years if there is an acknowledgement and a
Correct.
promise to pay, then it will be 25 of the contract.
Correct, correct.
એટલે બંનેમાંથી કશું છે, that is one.
That is
And if there is an otherwise contrary running and continuous account, then the limitation would simply not begin.
correct.
So બંને તરફથી what is the reasoning is what
So-
I am very interested
Correct.
to know.
So, but my question and answers which I'm referring to
Hmm.
is, I have a question. Cross-examination of, okay, I believe was there any? No, not the 24. No, they have extracted the whole thing. My written submission, I'm extracting only the relevant.
जी.
Okay. Milord, question number 2 at page 31.
Yes.
Do you know that on 24/4/2003, ONGC filed an application, Exhibit 23 in CMA 85 of 82 for recovery of X crores claimed as difference in price of natural gas supplied during the period of 82 to 87 from GSFC? Yes, I know about the said application, but I do not know the details to support the same. What is the period of dispute in the present suit? The period of dispute in the present suit is from 82 to 87. Did ONGC continue to supply gas to GSFC even after 81? Yes. Under which contract? The contract expired on 25/12/81, but there was a price agreement for supplying gas up to 82 at the existing price. Was the price agreement reduced into writing? This was in fact an order from the state government to supply gas at the existing price up to 82. Thus, I take it that there is no agreement between the parties between 81 to 82. There was no signed agreement, but ONGC has forwarded draft agreement which was under consideration of GSFC. In fact, ONGC has supplied to GSFC even before the signing of the formal contract on 69 by starting the gas supply prior to this date of signing from some error here. Is the state government order to supply gas at existing rate on record of this proceeding? No, it is not on record. Did ONGC continue to supply gas to GSFC even after 82? Yes. Under which contract? The contract was not extended, so there was no contract. Under what provisions were invoices raised by ONGC after 82? As there was no signed agreement between ONGC and GSFC, ONGC continued to raise invoice on GSFC as it was being done earlier expired agreement, which was not renewed by GSFC, and as per the draft agreement mentioned earlier. At what intervals were the invoices raised? ONGC was raising invoices on monthly basis. Did GSFC make payment in pursuant to such invoices? GSFC continued to pay ONGC at the rate of expired contract. Did ONGC issue any demand letters on a monthly, quarterly, biannually, so-and-so? I don't know. Witness volunteers to say that ONGC continued to follow up so-and-so. Did GSFC ever agree to make such payments of differential amount? No. Did ONGC institute any recovery proceedings against GSFC for recovery of the said amount at the relevant point of time? No. This is very relevant. Was there any prohibition against institution of such recovery proceedings against GSFC? No. However, the matter was at the central government level from 87 onwards. Did ONGC institute any recovery proceeding against GSFC for recovery of the said amount at the relevant point of, okay. So, para 31 of the affidavit, you have said that the present suit is filed within limitation and the same is not barred by law of limitation. What is the law permitting to limitation? As per my understanding, it's a period of 3 years from the last cause of action. What is the period of limitation for filing the present suit? 3 years. From which date is the limitation period to have commenced in the present suit? This becomes relevant. 22/6/2005, which is the last date of letter from MOPNG to ONGC, is the last cause of action. I put to you that order dated 16/4/82, passed in CMA 85 of 82, by no stretch of imagination, restrain ONGC from initiating any recovery proceedings against GSFC. Am I right? Maybe right. The learned advocate for the plaintiff has brought out and orally submitted that the cross-examination Vide Exhibit 71, Sri Abhishek Tushar Shah, manager of the authorized signatory of so-and-so, which was done by the plaintiff pertaining to the issue of leverage, can be considered when deciding as under so-and-so, so-and-so. And the reasoning then that is how they do it. So at paragraph 22. May I read from paragraph 22?
Yeah.
Others, they're, I don't know, let me see. All right, paragraph 12 onwards.
Yeah.
Let us see how the facts are discussed. On perusal of the above facts and circumstances and cross-examination of parties, I would like to discuss first of all that as per the order and direction given by the Honorable High Court of Gujarat in SCA number 7, issue number 8 is decided as a preliminary issue. There's no dispute between the parties about the plaintiff and the defendant entered into an agreement in this, which expired on this. On perusal of the record, notice dated this issued by the defendant to raise a dispute which was produced. So this is a dispute. When we stated that we want to appoint an arbitrator, the learned trial court records that it is a dispute which you have raised. So there is no acceptance. We are saying there is a genuine price dispute. Was declared as sole arbitrator thereafter. Notice dated 24/3/82 issued by defendant, which is produced at Exhibit 44. The defendant's learned advocate informed that has appointed so-and-so, retired Honorable Justice so-and-so to act as sole arbitrator. On perusal of the record, the plaintiff filed civil miscellaneous application 85/82. The civil judge Vadodara, under provision of the Indian Arbitration Act, in the CMA before passing the order, the Honorable Court, order and injunction application had asked for a declaration from the plaintiff that it will not stop the supply of gas to the defendant of the present suit, even though the contract had expired in 81. As per the direction given by the Honorable Court, plaintiff had given a process accordingly. An injunction as prayed for in para 11, which is produced with the Exhibit 49 is on record. In fact, the Honorable Court said, if you wish to obtain a stay, you need to file a process that you will continue. Then arbitration proceeding may not proceed. That is the proceed. To say that it was directed, there is no such direction in the record. This is not correctly recording things as they emerge. In any which case, as emerged in the cross-examination, the Honorable Court has not precluded you from recovering, from taking any steps in accordance with law. On perusal of the letter dated 25/6/82 is a letter of the plaintiff. Though the letter the defendant informed that the price of gas would be required to be adjusted to the price of naphtha prevailing from time to time. The price applicable worked out in terms of the provisions at 2100 per 1000 metric cube from 82. The same was not considered because the defendant did not pay the demanded price. The plaintiff written a letter. The price of gas to be adjusted would be on record at exhibit this. This is also of 82. On perusal of the record, CMA 85/82 stated by the Honorable Supreme Court on 24/8/84 till disposal of the cases. As per the contents of the averments of Exhibit 1, during the pendency of CMA, which is pending in the Court of Vadodara, the Government of India fixed the price by notification dated 87. Government fixed at 1400 per 1000 metric cube. The notification pertaining to that is on record. A comprehensive note submitted on 5/5/87 regarding the dealing of the dues from PSU, which is produced at Exhibit 191. My lords have seen it. Further, prior to ONGC Repeal Act, the plaintiff was directly under supervision of the Ministry of Petroleum and Chemicals. So this was their argument. Therefore, I refer to the repeal. From 93, you are a body corporate, you are independent, you are not under the government, you are a listed company, listed at the National and Bombay Stock Exchange. As the plaintiff was under the aegis of the Ministry of Petroleum, the plaintiff also submitted a letter to the Ministry of Petroleum in 1990, which is produced as this. On perusal of Exhibit 191, 193, it transpires that the plaintiff had demanded his dues from time to time. This communication is not a demand of dues.
What are these 91 and 93?
Yes, I had taken, my lord, these are notes which they have forwarded to the ministry.
Okay, I recall now.
This is not a demand raise. My lord, how is this finding even tenable? Plaintiff had demanded his dues from time to time and submission for the same also inter alia till the date of submission pertaining to the demand. Defendant has not paid. So admittedly, till you have preferred a note before the ministry, there is no payment. If there is no payment, your cause of action has long arisen. Considering the documentary evidence which is produced at Exhibit 96, it is a copy of the MOU which is executed between ONGC and GAIL. As per the said MOU, the marketing activities of ONGC were handed over to GAIL in 92. And considering the documentary evidence which is produced at Exhibit 97 is a copy of the contract between GAIL and the defendant of the present suit GSFC, which was executed on 30/12/94. And both the parties entered into an agreement for sale, purchase of gas. Thereafter, the agreement of sale has been extended from time to time. Considering the above facts of record and read it with the averments of Article 2 of the agreement, which is at 97, which is executed between GAIL and the defendant, it is reproduced under. This I have read, which said the term is from 94 to 2000. 2 years prior thereto, from 92 to 94 will be liable. Also, we say that ONGC shall continue to be, we will be entitled. For the past dues, we continue to remain, let me read that.
Yes, I recall that.
Yes. This ends in 2000.
The last
The-
portion is material
Yes,
where we can say
material.
that if you.
Correct.
Yes.
And in case we are not able to pay, you stop the supply.
Correct.
When the issue of arrears was taken up with GAIL, a notice dated 2004 was given by GAIL for the dues of the plaintiff for the principal amount and interest both. Pausing here for a moment, it is noteworthy that in 2003, they moved an application in that CMA
Ji.
for recovery. But here notice is given by GAIL, not by ONGC.
Now we could, take, yes,
ah.
it's 2 o'clock now.
Okay,
So we'll,
we'll continue. I'll complete reading. I'll complete my submission.
Right.
Great.
अब ये तारीख कब से? સવારના પેલા ઓર્ડર્સ હતા એ ક્યાં છે? લાવ. બોલો.
પ્રતિવિવાદી છે સર રેકોર્ડ આવી જાય તમે ચાલવી દે
મંગાવી લે યાદ. તારીખ આપી દેશે તમને. હા તો જોઈ લેજો તમે પેલા. જી. બોલો.
RCA 41 number છે આના આપનું 14 સિનિયર નંબર 14 RCA 41
1-4.
41
હા જી.
અમદાવાદી મૂળ ચાપાનેરી વણિક જ્ઞાતિનો પ્રમુખ છું.
હા જી.
અમદાવાદી ચાપાનેરી એટલે પ્રતિવાદીમાં છું, પ્રમુખ છું સમાજનો.
જી. ભૂમિયા સાહેબ ક્યાં છે?
એ આવે છે, મેં ફોન કર્યો, હવે આવે છે. મીનવાઇલ એક બે વાત કરવી હતી સાહેબ તમને કે એ ભાઈ કેટલા વખતથી ભાડું પણ નથી આપતા અને એક તો ઘૂસી ગયેલા છે.
આજે
સમાજની ચેરિટી કમિશન
સાંભળો,
ટ્રસ્ટ એક્ટમાં
સાંભળો.
હા સાહેબ.
આ મેટર છે ને આજે કદાચ સાંભળી નહીં શકાય. એડવોકેટ જનરલ અને સોલિસિટર જનરલ બંને આવ્યા છે અને બંનેની મેટર આજે સવારથી ચાલે છે, એ સાંજ સુધી ચાલશે. એટલે કદાચ એમાં બીજો પેલો આપનો નહીં આવે એટલે તારીખ આપશે. જ્યારે નેક્સ્ટ તારીખ હોય ને ત્યારે વકીલ સાહેબને કહેજો બરાબર રજૂઆત કરે. હું હુકમ જે હશે કાયદા પ્રમાણે પાસ કરી આપીશ. હા,
સમાજને નુકસાન થાય છે ને એટલે
આ પણ સમાજને બધું એક સાથે 5 હિયરિંગ તો હું કરી નહીં શકું. એટલે આપનામાં 15-20 મિનિટ કલાક એક તો જાય ને એટલો સમય આજે નહીં રહે મારી પાસે. એટલે આખી કોર્ટ હમણાં બહાર ગઈ છે. પેલા બંને સાહેબો આવશે એટલે બધું
GSFC નો સવારનો
આપણે નહીં, એટલા માટે નહીં થઈ શકે.
તો તારીખ આપો છો
હા, તારીખ આપું છું.
ઓકે, ચાલો
જી. નેક્સ્ટ ટાઈમ જે છે ને એ જોઈ લઈશું. નેક્સ્ટ ટાઈમ જોઈ લીજે તારીખ હોય એમાં તે દિવસે વકીલ સાહેબ ને કહેજો સવારના આવી જાય 11 વાગ્યામાં, 11:15 ત્યારે દલીલ સાંભળશું. બરાબર.
ઓકે સર, થેન્ક યુ સર.
જી.
જય શ્રી કૃષ્ણ.
हमारी दलील હતી ક્યાં ગઈ કે નથી આમાં કઈ દલીલ હતી મારી કે લખીશું ને નામ કે તે દિવસનું બોર્ડ મારે જોવું પડશે નહીં તો આ જયારે દલીલ થઈ ને તે દિવસ તમે ઓબ્જેક્શન હતું મને યાદ છે
બોર્ડ કાર્ડ છે
આ કરી દીધું આમાં રોજ કામમાં જોઈશું પહેલા રોજ કામ આગળ મારી કોપી મળે છે વકીલ સાહેબ સોરી આજે આપને બી ત્રણ સાહેબ આજે I don't think witness will be possible because that matter they said one session and after one session
नहीं, साहब,
party
नहीं,
also has not concluded
बरोबर
so it will continue
maybe
till-
keep some other day
હા,
maybe keep
એટલે witnesses ને will
मैं એમને કહી દઉં
હા.
હું એમને કહી દઉં
આપને બપોર સુધી બેસાડી રાખે
જી,
sorry.
નહીં
ખાલી એટલું પૂછો ને કે આ જે છે ને આ કોર્ટમાં જ રાખ્યું છે આપણે ઠીક છે ભલે ના નહીં ચલો
I apologize.
not a problem
We were
એ તો સુધારવા માટે મોકલી દઈશ યસ પ્લીઝ
please. I was on page 70, last referring to
જી
last referring, Manoj, to the agreement between GAIL and the present appellants.
Ji.
Thereafter, paragraph 23. When the issue of arrears was taken up by GAIL, a notice dated so and so 2004 was given by GAIL for dues of the plaintiff for the principal amount and interest therewith. Thereafter, the defendant filed special civil application, which means the appellants, before the
Which
Honorable
is
High
the internal page that you are reading?
I'm reading internal page 40.
Yes.
Which is the special civil application 15849 before the Honorable High Court during the pendency of SCA, meetings executed time to time. Subsequently, Ministry of Petroleum and Natural Gas, with its letter dated 22/6/2005, advised the plaintiff to defend its interests appropriately, taking into account inter alia the contractual provisions, and the matter was primarily a commercial dispute between commercial organization. Therefore, the present suit for recovery of differentiate amount for the period from 1,481 to 16,592 for the amount of arrears working out to so and so, so and so. As per, so my lord, even so, what weighs with the Honorable Court is that the last breaking point, which is referred to, my lord, as that terminology is used by the Honorable Apex Court to say, where is that breaking point? In my submission, that breaking point goes way beyond. It goes somewhere in the 80s, when for the first time we issue an arbitral notice. But in any which case, this cannot be considered as a breaking point. The Government of India advising, it is a body corporate way back in 93. In 2005, an advisory issued by Government of India, it's not even an advisory. You preferred a note because the Government of India was endeavoring to resolve. You preferred notes, and that note is of 90 after 15 years. And internal communications or negotiation, we've read it, would not extend the limitation. Therefore, the present suit filed for recovery of differentiate amount for period from 81 to 92 for an amount of arrears so and so. As per the say and defense of the defendant is that the plaintiff had filed the suit in 2008, claiming principal amount of so and so plus interest amount of so and so, occurring till 2008. Further interest at 18% from the date of filing of the suit till realization. The said amount is claimed inter alia for gas allegedly supplied by the plaintiff to the defendant from 1/4/82 to 29/1/87. The reason with the date 29/1/87 is because from 30/1/87, Government of India gas pricing comes. And the onus to prove that the suit is within limitation is on the plaintiff. And the Honorable Court has also put onus on the plaintiff to prove that the issue of limitation at serial number 8 is of the issue frame. As per the submission of the defendant, the cause of action did not arise any of the events narrated in the plaint, but arose on the date of delivery of gas as per Article 14 of the Limitation Act. The last delivery was 29/1/87. Thus, the last cause of action for filing of the suit arose on 29/1/87. The defendant states that the plaintiff does not disclose as to how the cause of action arose on all the events narrated therein, or as to which article of the Limitation Act does the present suit fall. So there is no explanation on that. Further, the case of the plaintiff that the period of limitation for filing the suit, which last arose on 29/1/87, was suspended by virtue of any of the provisions contained in the Limitation Act. As per the defense of the defendant, is that the parties had entered into an agreement in 69, which is produced at so and so, which was valid till 81. Before the expiry of the said contract, the plaintiff opposed the execution of fresh agreement from 82 onwards. So this is when we issue the arbitral notice, etc. The defendant on various occasions refused to execute the draft agreement with revised price. The defendant also requested the plaintiff to extend the earlier agreement. However, the plaintiff did not agree to the same. Therefore, the defendant, through learned advocate, issued notice on 2/3/82, which is produced as Exhibit 43, invoking arbitration, which contained in contract dated 3/1/69, and appointed Honorable Mr. Justice Shelat as the arbitrator rather than appointing arbitrator. The plaintiff filed civil miscellaneous 85/82, which is produced at Exhibit 48 on record. So and so on. I'll go next. As per the submission made by the learned advocate of defendant, that since the delivery of gas was made from 1/4/82 to 87 without there being any contract, and also since invoices issued by the plaintiff do not prescribe any period of payment, the present suit would fall under Article 40 to the schedule to limitation of 63, which prescribes a limitation period of 3 years from the date of delivery of goods for filing of the suit for the price of goods sold and delivered, where no fixed period of credit is agreed upon. Therefore, as per Article 14, limitation period for filing of the present suit commenced from the date of delivery of goods. Thus, the last delivery of the disputed period was 29/187. Thus, the suit ought to have been filed within 3 years from 29/187. However, the plaintiff did not institute any proceeding for recovery of the differential amount at the relevant point of time, and hence the plaintiff lost its rights, if any, to claim the amount from the defendant, and the plaintiff has not filed to, and the plaintiff has lost the right to present the suit after 21 years from the last date of supply, has also submitted that the present suit is hopelessly barred by the law of limitation and thus is required to be rejected. In the context of the submissions, my lord, everything is concluded in just 2 paragraphs, and I take my lord.
Yeah.
In the context of the submission, defense of the defendant's sides, considering the averments of Article 2 of Exhibit 97, the dues duly accepted by the defendant for the period from 1/4/1981 to 16/5/92, and any arrears earlier for the period from 16/5/92 respectively, then the ministry had advised very first
This
time.
dues duly accepted, what does the court mean? when
The
it
court
says-
is saying that because your Article 2 of your agreement with GAIL
Ah.
stipulates that
Ah.
you will continue that for this agreement is from 94 to 2000. However, you are liable for 92 to 94 also, as also for the past dues.
Okay.
So this, he says, is extending limitation. And as per the advice of the ministry, so thereafter, the ministry had advised very first time on 2005. And as per the advice of the ministry, the dispute raised between the parties were commercial nature. Therefore, after service of notice, the present suit filed by the plaintiff on 2/5/2008. Further, because of the order passed in CMA, so these are all this is the reasoning. In 2 paragraphs, all the reasoning is concluded. So this is it. Further, because of the order passed in CMA, the plaintiff is duty bound to supply gas continuously, though the period of agreement was expired. In spite of getting the facility of gas supplied continuously, and the plaintiff having given invoice regarding the supplied gas from time to time continuously. Similarly, while the defendant did not make payment to the plaintiff, such arrears of the dues claimed by production of comprehensive notes dated 5/5/87 and 24/4/90 be put before the ministry time to time, and there is no reason to disbelieve that the whole affairs, meetings of discussion about arrears were going on between the parties, and the earlier arrears for the period dated 82 to 87 and other than that were duly accepted by the defendant as per the agreement which was executed on 30/12/94, Exhibit 97. Therefore, it is crystal clear that the acknowledgement of the dues earlier were accepted on 30/12/94. Further, the defendant argued that the witness of the plaintiff has admitted, Milord, accepting, even going by this, even without admitting, go by 94, as the learned trial court is saying. Limitation ends in 97.
Ji.
Further, the defendant argued that the witness of the plaintiff has admitted during cross-examination that there was no restraint on the plaintiff to initiate recovery proceedings at the point of time. I would like to note that similarly, the defendant was also not restrained by any authority to pay the dues to the plaintiff at the relevant point of time. I have no comments to offer for this.
Yes, please.
Before the filing of the suit, whenever the affairs, proceedings, meetings were going on between the parties, the defendant had not taken any single defense at the relevant point of time regarding arrears dues being barred by law of limitation. My lord, we have raised the issue of limitation everywhere. The foundation of my writ petition was it's barred by limitation. This limitation issue is to be decided, which is what we've been telling the court. Let limitation be first decided, which is the multiple orders passed by the Honorable Court. The learned advocate for the defendant argued that the Honorable Supreme Court in the case of Southeast Asia Shipping versus Now Bharat Enterprise has held as follow. It is settled law that cause of action consists of bundle of facts which give cause to enforce the legal injury for redress in a court of law. The cause of action means, therefore, every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of court. This court is duly agreed with the settled principle of law of the above referred citation, but on perusal of the record and the discussion made herein above, plaintiff duly proves every fact in order to support his right that a plaintiff suit is filed within period of limitation. How is the burden transferred to us? The Honorable Court holds that you have not taken any steps to say that it is barred by limitation. It is when you file a suit that I raise the objection on limitation. In your application which you filed, before the in civil miscellaneous application, 85 or 82, my written submission is that it's barred by limitation, but it's not my obligation. Law casts the burden on the plaintiff to prove. The learned advocate for the defendant argued that the Honorable Supreme Court, in the case of A.Y. Ajit versus Sofana Ajit, reported in so-and-so, as well as in the case of Church of Christ Charitable Trust and Education Child so-and-so, has followed the said proposition of law. The learned advocate for the defendant argued that in view of the above settled legal it is submitted that the cause of action in the present case arose when the delivery of gas was made by the plaintiff. Thus, the cause of action arose on 29/187, that is when the supply was made. It is submitted that the plaintiff has not pleaded if the cause of action, which arose as per Article 14, was suspended on account of any provision of the Limitation Act. Now, this be noted, there is not a single pleading on suspension, and that the present suit is filed within the limitation period after deduction of the period during which the cause of action is suspended. In this regard, reliance is placed on the judgment of the Honorable Supreme Court in P.K. Kutty Anuja Raja versus State of Kerala, reported in 1996 2 SEC, paragraph 3496, whereof is extracted herein below for the sake of convenience. In A.S. Nambiar, learned senior advocate counsel, appearing for the appellants, contended that the appellants had discovered the mistake on 5/10/71 when this court dismissed the appeal filed by the state against the orders passed in so-and-so, and therefore the limitation begins to run from that date. Therefore, the suit was filed within 3 years, and such was not beyond time. High Court was wrong in holding that the suit was barred by limitation. We are unable to agree with the learned counsel. It is not in dispute that at his behest, the assessment was quashed by the High Court in the aforesaid OP so-and-so. Thereby, the limitation started running from that day. Once the limitation starts running, it runs its full course until the running of the limitation is interdicted by an order of the court. Section 3 of the Limitation Act gives the power to the entertaining the suit, which says that subject to the provisions contained in Section 2 to 24, every suit instituted after the prescribed period shall be dismissed, although limitation has not been set up as a defense. Therefore, if any period of limitation is to be excluded from the prescribed period of limitation, the party necessarily has to satisfy any of the appropriate provisions of Section 4 to 24 of the limitation. This is not one such case. Under those circumstances, limitation having been begun to run from 68, it stood expired by a flux of time after 3 years. Therefore, from 71, the right to recover stood barred by limitation. Pendency of the appeal, unless the operation of judgment is suspended by this court, does not amount to suspend the operation of the running of limitation. We do not find any such plea raised by the appellant in this case. In that behalf, therefore, the High Court was right in finding that the suit was barred by limitation. This court is duly agreed with the settled principle of law, the above referred citation, but on the date on 29/187 cannot be considered as the last date supplied, because of though there is no fresh agreement executed between the parties, as per the order of CMA, the supply of gas was continued from time to time by ONGC, and the defendant has not raised any objection for the same. Hence, as per the facts and circumstances of the present suit, the court believes that the citation which is relied upon by the defendant does not helpful to the defendant accordingly. So the interim order passed by the Honorable Court staying arbitration proceedings upon a purchase being given by the plaintiff saying that they will continue is considered to be a mandate of the court, which is precluding them from initiating proceedings for recovery of arrears in price determined by them. There is no order staying limitation. There is no order precluding them from initiating filing of a civil suit. And in fact, my lord, it is not, this may be the finding, but the Honorable Court is not noticing that they themselves in 2003 move an application for recovery. So if this order is precluding them, they would not have moved an application there. They move an application before that forum seeking recovery.
So you say that because there was no, they were not precluded.
They were
This is
precluded.
an indication of the same.
Absolutely, absolutely.
Ji.
The learned advocate for the defendant argued, and in fact, my lord, they were desirous of arbitration not to proceed. Therefore, the conditional stay granted. It was open for them to say, we decline to submit, we decline to supply any more gas. We don't want the stay order, and we proceed with the matter. Let the matter be argued on merits. It was an order 39 rule 1 order. We are ready to argue on merits. Whether in law we could have done it or we could not have done it, appointment of a sole arbitrator in terms of the clause of the agreement, contract agreement, gas supply agreement, we are ready to argue the matter. It is not as if the court mandated you that you give purses. You wanted a stay, to which the Honorable Court put in a condition. The learned advocate for the defendant argued that in view of the above judgment, it is submitted that the limitation period having sun to run from the respective dates of delivery of gas was not suspended by virtue of any provision of the Limitation Act. Limitation lapsed on 3 years from so and so. The present suit is filed on 258. For the defendant argued that plaintiff has vaguely submitted that he did not file the suit at the relevant point of time, since the issue of recovery of differential amount from PSUs, including the defendant, was pending before the Ministry of Petroleum and Natural Gas. Only after the ministry's letter of 22/6/2005, the plaintiff was enabled. This submission or this even summation of the arguments of the plaintiff that it was enabled. It's a body corporate. Under a statute, there is no enabling required. It is just as you are free to enter into the contract, you're bound to take necessary action in law. And that in any case in 93, you became a body corporate. Earlier also you were, but thereafter the ONGC Act came into existence. You're a listed company. In this context, it is submitted that the plaintiff's witness has admitted during his cross-examination that there was no restraint on the plaintiff from filing a suit between 87 to 2005. Thus, it is clear that despite there being no prohibition, the plaintiff voluntarily chose not to file the suit in 87, let limitation period expired. It also became clear that the submission or pendency of issue before the ministry is nothing but clever drafting to bring the suit within limitation. The Honorable High Court in the case of Becharbai, and Becharbai has been read twice over before the Honorable Court. The learned advocate for the defendant argued that the Honorable Supreme Court in Metal Forging versus Union of India, reported in 2003, has held that is a settled position of law that unless and until there is a specific injunction or stay granted by competent court, which restrains an authority from issuing the required notice merely because some interim order is made, the authorities empowered to issue such notice cannot refrain from issuing the required notice within the period of limitation, nor can they plead the existence of such interim order as a defense against the plea of limitation. Learned advocate for the defendant argued that the events narrated in para 29 of the plaint do not give rise to the cause of action for filing the present suit. Thus, it is the only event which can be said to be giving rise to the cause of action to the plaintiff for filing of the present suit, the defendant's payment of so-and-so despite invoice value so-and-so. The plaintiff to no action for initiating recovery proceedings at the relevant point of time. Subsequent events such as judgment of the Supreme Court in 1990, execution of agreement between defendant and Gale, execution of MOU between the plaintiff and Gale, judgment of the Honorable Supreme Court in 2001, issuance of notice by Gale and the plaintiff's MOPNG letter dated 26/2005 did not give rise to a fresh cause of action to file the suit, and that once limitation period expired on expiry of 3 years from the last date of the part payment, the plaintiff lost any right whatsoever to raise the claim and file the present suit. This court is duly agreed with the settled principle of law, the above referred citation, but on perusal of the record, as per the contents of Article 2 of Exhibit 97, the dues duly accepted. This is the same, my lord, as Gale's, that same as I read earlier, the same reasoning. That same reasoning, my lord, would you please to find
Yes.
at page 76. Identical. I'm sorry, internal page 46. So what is at 48? Reasoning is also at 46. Thereafter, the ministry advised for the first time in 2005, based on the advice suit file, and thereafter another judgment is referred to. And I'll only read these because all the judgments are cited. I'm not going to read further from any of my submission. These judgments are all covered. In ABC Laminate Private Limited versus AP Agencies, 1989, 2 SCC 163, a cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it's a bundle of facts which, taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. It must include some act done by the defendant, since in the absence of such an action, no cause of action can possibly accrue. It is not limited to the actual infringement of the right suit, but includes all material facts on which it is founded. It does not comprise evidence necessary to prove such fact, but every fact necessary for the plaintiff to prove to enable him to obtain a decree. Everything which, if not proved, would give the defendant a right to immediate judgment must be part of the cause of action. But it has no relation whatever with the defense which may be set up by the defendant, nor does it depend upon the character of the relief paid by the plaintiff. This court duly agreed with the principle of law referred to in the above citation, but on perusal of the record of the defendant, has not proved any fact against the dispute between the parties would not be treated as a commercial dispute. Hence, as per the facts and circumstances of the present suit, the court believes that the citation which is relied upon is not helpful to the defendants. The learned advocate for the defendant argued that the Honorable High Court in the case of Banwali Lal versus Municipal Corporation of Kanpur, reported in so and so, as held, once limitation has begun to run, the mere fact that plaintiff made another attempt to get the municipal board to alter the decision would not have the effect of stopping it or giving it a fresh period. The other judgment relied upon at internal page 50, AIR 1965, Supreme Court 1147. The contention, however, is without foundation, for under Section 9 of Limitation Act, once time starts running, it does not stop to do so. And there is no dispute that the time began to run from the date of the appellant's decree when the right to apply first accrued. The learned advocate for the defendant argued that the said legal position has been followed in the following judgments. The learned advocate for the defendant argued that in view of the above settled legal position, it is submitted that the limitation period for institution of the present suit commenced in 87, did not stop, therefore cannot continue till 2008. This court is duly agreed with the settled principle of law of the above referred citation, but on perusal of record, as per the contents of Article 2 of Exhibit 97, the dues duly accepted by the defendant on the period from 81 to 92 and any years earlier for the period of 16/5/92. Then after ministry advice, so 92, then ministry advice 2005.
Ji.
Page over. Again, the reference to the CMA. Further, the plaintiff has supplied of gas continuously to the defendant, though the period of
જોઈ ગયા
agreement.
છે આપણે.
That
એટલે this is repetition basically. Yes.
repetition, yes. The witness of the plaintiff has admitted during cross-examination that there is no restraint to initial recovery.
Yeah, આવી ગયું છે.
Similar, એ જ છે પછી. Then other judgments relied upon. Then next, internal page 52.
એમાં 10 કરોડનું acknowledgement ની વાત કરે છે.
Hi, 10 crore.
પછી next
Then
53 ઉપર
53 per
simpliciter does not help. Then
does not help. And
okay.
nothing on. Agree with the principle of law, but then Milord, another, I'm reading Bharat Sincha. Internal page 55.
जी 112 तो प्रेस करता નથી तो there we need not go into.
Sir, we don't. Then we rely on judgments relating to section 3. I'll just go to his findings. All of them are. Sorry. Sorry? Yes. Milord, I think we may start reading from. We'll start reading from page 94, internal page 64.
64
64.
जी
The above citations are produced by the defendant, and considering the fact of the citations, those are produced on the different grounds, that is merely negotiations, will not postpone the cause of action. Family settlement, and though agreed with the same, and discussion for negotiations were going on, correspondence between the parties would not give accrual to fresh cause of action. The appointment of an arbitrator regarding non-payment of the dues, appointment of the sole arbitrator, such reasons would not give accrual the fresh cause of action for filing of the suit. This court is duly agreed with the above citation. But on perusal of the present suit, not only negotiations continued, but also acknowledgement of the debt had been done by the defendant.
where is that?
That acknowledgement, my lord, repeatedly they're referring to that Gale agreement, which is of 94.
Who is to am I supposed to acknowledge third parties or to the
This
Main-
is the third party, but that acknowledgement has reference to past due of ONGC.
okay
So it says that, may I take my notes to that?
Yes, please.
Once again, let's just see that. That document only, because
Article 2.
Article 2. So the learned judge is either relying on Article 2 or it is relying on MOPNG communication of 2005,
MOPNG
Or
communication
thirdly,
है हाँ
or it is thirdly relying on the interim order passed below the pushes.
जी
In arbitration, in a civil miscellaneous application, 85 of 82 filed for stay of further arbitral proceedings.
जी
That
આ કયા વોલ્યુમ માં છે
volume 2,
Also,
volume 2, relevant page 346, but clause 2 is 349.
yes
This contract
yes
This contract shall come into force from 30/12/94 and shall continue to remain in force for a period up to 31/12/2000. Subject to the condition that the arrears receivable by the seller from the buyer on account of supply of gas by the seller to the buyer for a period from 16/5/92 to 29/12/94, and any arrears receivable by ONGC from the buyer on account of the gas supplied earlier by ONGC to the buyer for a period prior to 92 shall continue to be receivable
Ji.
by the seller / ONGC, as the case may be. And the buyer undertakes not to fail to discharge the said obligation.
Buyer is applicable.
Yes. Discharge the said obligation of clearing such arrears directly with ONGC. The buyer further agrees and undertakes that in case of failure or default on its part to discharge such obligation, the right and or claim to receive the supply of gas either under the contract or any other manner whatsoever shall not survive. The consequence is shall not survive and shall automatically stand forfeited or terminated.
Let us go to 18.
Section 18. Effect of acknowledgement in writing, where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. Assuming that this is an acknowledgement, this acknowledgement is signed in 94.
Ji.
So again, I was reading what he was. This court is duly agreed with the referred citation on perusal of the present suit. Not only negotiations continued, but also acknowledgement of the debt, that is 94, had done by the defendant, and in this regard, the amount were paid in 2 installments. And as per the record, last installment was deposited on 7/1/2005. Milord, this is where the perversity comes. Milord, every fact linked to the issue is connected to say everything is the cause of action, which makes it continuous and thereby extending period of limitation. There is not a single pleading with regard to suspension of the period of limitation. Not a single line. And an amount which is paid without prejudice to show bona fides cannot be an admission of the debt.
Ji.
This court is duly agreed with the principle laid down in the above citation. This court is not agreed with the argument of the defendant that the present suit is barred by law of limitation. Further, it came on record that even though notification declared by the plaintiff on 31/87, an amount of dues were demanded by the plaintiff from time to time, but no cogent reason or facts or documentary evidence produced in this regard simultaneously. Defendant has not proved at that time why they have not paid the amount when demanded by the plaintiff.
Ji.
Each notice is replied to. Anyway, the burden is on the plaintiff. The burden is not, Milord, completely a somersaulting of the burden.
Ji.
This is, Milord, in my submission, most humble submission. It's a convoluted argument. there is admittedly no material to establish that the demand is made within the period of limitation. Not a single document to establish that the demand is made within the period of limitation. We continue to play as per the old agreement, and after the government of India in 87 determined the price from 87 onwards, we've been paying as per the government of India's prescription.
Gee.
It is also pertinent to note that when GAIL issued notice on 11/2/2004, then after defendant filed SCA before the Honorable Court, and as per the order of the Honorable Court, the defendant deposited an amount of 10 crores as an installment. If the dues of the plaintiff were time barred, defendant did not deposit the amount of 10 crores as installment. My lord, absolutely convoluted. Factually not true.
Gee.
While the proceedings of SCA number so and so were going on before the Honorable Court, the defendant have not raised any objection pertaining to the dues of the plaintiff claim. It was barred by law of limitation. Hence, as per the order of the Honorable High Court of Gujarat, defendant were deposited the amount of 10 crores as an installment on so and so. Therefore, this court has reason to believe that the arrears of dues were within limitation till 2005. Till 7/1/2005. Let me pause here for a moment. Here the Honorable Court is saying that I'm pushing the limitation to say, till you paid the installment, it's under. Factually, absolutely not true. My lord, in my most humble submission, it is perversity to say it is an installment. It is not an installment. Not one word in the that order can say it is an installment. It is to show the bona fides. We have said we are ready to deposit this. And even if you take this date, which, my lord, the learned trial court is taking 7/1/2005, the suit is filed subsequently. It's 2/5/2008 that it is filed.
Even
Then after
from
he
this
said-
also more than 3 years.
Yes.
Gee.
4 months further. Then, my lord, what the trial court does is goes to that advisory. Because that's the last date within which, the only date within which they can bring. So, considering the order made by the High Court of Gujarat, therefore, as per interim order passed by the Honorable High Court, this court has cogent reason to believe that the earlier arrears of amount of dues of the plaintiff is duly recoverable during the pendency of SCA. My lord, these findings are not sustainable. Therefore, as per the interim order passed by the Honorable High Court, this court has cogent reason to believe that the earlier arrears of amount dues to the plaintiff is duly recoverable. We are challenging a notice issued by GAIL. We are saying GAIL, these dues are not of GAIL, even which we say without prejudice, we will deposit a certain amount. It is neither installment nor an admission. And they say that it becomes recoverable. Then the Ministry of Chemicals and Fertilizers called a meeting to discuss the issue of the cases. In continuation on the date, on 22/6/2005, MOPNG advised the plaintiff to defend its interests appropriately with a letter date. Dispute between the parties is a commercial issue, so and so. So this date, so three dates they take. One date is with regard to that agreement of 94. Second date is when the order is passed by the trial in civil miscellaneous application 85 of 82. And the third date they take is 22/6/2005, which is an advisory. You know, advisories do not confer limitation. There is no stay, no any injunction, no interim order. Perusal of the provision, which provided in Article 40 of the Limitation Act that for the price of goods sold delivered, where no fixed period of credit is agreed upon, the period of limitation of 3 years, which begins to run from the date of delivery of the goods. In this regard, considering the above whole facts and circumstances, the chargeable amount dues during the continuation of the dealings between the parties between 81 to 2005, the amount of 10 crores last installment deposited on 7/1/2005, the said amount which is deposited was forming part payment of the dues which was demanded by GAIL for the period of 1481 to 1892. My lord, how is this finding arrived at? Part payment concepts are completely different in law. And as per the content of Exhibit 97, Article 2, the defendant has duly accepted the arrears receivable by the seller for the period from 92 to 94, and any arrears earlier period prior to 16,592. Hence, the disputed amount during the period from 82 to 87 is contained in the period of any arrears earlier for the period of 16,592, when payment of any item in a series of sales and deliveries of goods were paid, and such payments towards the particular goods or sale and deliveries of the goods, the period in limitation in respect of extending from that. Hence, the date of delivery of the goods was extended continued. Whenever the plaintiff, ONGC, had supplied gas to the defendant, that is GSFC. Pausing here for a moment, last delivery is 87. ONGC has not made any delivery after 87.
Ji.
Therefore, any arrears pending from 81 to 92, it can be receivable by the plaintiff seller. And the ministry advised to put the defense before the commercial court on 22/6/2005. Therefore, 3 years completed on 21/6/2008. And the present suit is instated on 2/5 and it is within limitation.
Ji. Anything else?
So, my lord, the difference, the delivery of the gas by ONGC was till 92. But in 87, Government of India fixed the price. So therefore, the price which they are demanding is only till 87.
In any case, those amounts which are pertaining to delivery is till 87 is what you are.
Till 87. Till 87. That is what my
Thereafter,
contention is. Yes. Differential price is till 87. After 87, Government of India has fixed the price.
That the dispute is not before the court.
That is not. That's not. So therefore, my lord, in my submission, the judgments have all been read. They've been referred to by the trial court, and this is how it is read. 3 paragraph arguments for everything, and this is how it.
Yes.
With this, I close.
Bullard.
My sincere apologies that I have to go out.
Not an issue.
Sir, considering the amount of time left in the regular tribunal, or should we make appropriate to let me begin tomorrow morning? I'll finish my notes.
Our preliminary contention, if you want to contend, आज करेगा बाकी.
Instead of doing it in piecemeal, because the idea is that in 1.5 hours, I'll conclude everything, not only preliminary, but this, the main, because
आपकी
ultimately,
तैयारी में तो I'll give you 1.5 hours today.
maybe excuse for this.
I could give you a.
No, that is very kind of your office, but if it appeals to the honorable court, tomorrow afresh we can start and I
क्या
undertake to
તમારે
finish.
બધાને બહારથી આવવું પડશે?
No, I'm saying that.
હા એટલે
I have
you
an
have to
objection
give
that she
rejoinder,
will leave,
etc.
otherwise,
હા એટલા માટે.
no, I'll be here, because I'm here only, otherwise also the main matter is, the suit is listed tomorrow. So
Okay.
there also we will have to seek adjournment, because considering the pendency of this appeal.
What would
So I'm
you
here
have to
either
do?
way.
Come back.
Very well. Tomorrow.
Whichever time convenient.
Morning.
કાલ સવારે
I'll finish it in first session itself, I would not
Very
require this much of time.
Very well.
Yes.
My lord, would my lords pass an order extending the interim review? Since it is.
I'm here only, because
No, I don't
I will
mind.
mention
No.
the matter that.
No, the
appeal is
difficulty,
filed.
the last order, the matter was listed on Monday.
Ah.
And the honorable court has extended it till today.
Okay.
Just a formal, tomorrow it may not happen then.
લાવો.
Yes.
અઠવાડિયા દિવસ સુધીનો કરી દેવાનો.
The office will do it up to 5th, so that before that, which
Right.
is next Friday.
Very. No, પેલું endorsement તો કરાવી લો જો. Good thing about senior advocates arguing a matter
Right.
is that we don't have to read it inside once we go to the chamber. એટલું સરસ સમજાવી દે. અહીંયાથી હર્ડ કહીને જતા રહે તમે વાંચ્યા જ કરે ખબર જ ના પડે કઈ તરફ જવું.
Eventually, viewers, what happens is
એટલે
the
this
process
is
is
something that I would urge all the lawyers to try and imbibe કે એટલી સરસ તૈયારી જજોને કરાવી દો કે અમારે બીજી વાર વાંચવું ના પડે તરત
it is like
પાસ થાય.
sometimes rather most of the times it happens is that matters are dumped on your lordships rather than
Yeah, that's
present.
So difficult.
Rather than present it.
It becomes difficult for us to decide. કેમ કે
And then when,
ક્યાં ખૂણામાં કયો fact છે ખ્યાલ ના આવે કઈ મિસ થઈ જાય then they'll say blame the judge.
and
that is-
marshalling of the facts takes a
Very
lot of
difficult.
time.
Yeah, that's
It's a
all.
lot, and these are
And
little
that
complicated
exercise
facts.
is very apparent from that thing that the notes that you've done. So all of us, possibly you will also have to skip that exercise because એમાં કઈ જરૂર નહીં પડે.
Same,
સિવાય કે unless you want to point out a
document
specific.
કામનું બાકી નથી રહી ગયું.
જી, જી, જી. So that's
એક
a
પણ
very
એમનું હોય મારું કોઈ બી એક પણ
What
In fact, even
appreciates-
before the trial court, the notes or rather the compilations that were shared first inter se amongst us so that nothing is missed out.
જી, જી, જી.
Idea is to assist the honorable court to arrive at a
Correct.
just
So-
conclusion.
બરાબર છે. એટલે that is
and didn't make sense to read judgments again when submissions start already dealing with it.
જી, જી. સત્યાવીસ છે ને? Thank you. Thank you very much.
Grateful.
Very grateful to my lords.